I may be permitted to move one motion, my lord, on the after tomorrow.
What is the matter?
Matter, my lord, writ of key warrant for my lord, despite of losing the case, my lord, she is holding the post of the president.
Yes.
Lordship.
May I please, your lordship? Lordship, I am praying for a listing of a matter, lordship, today. And let me explain, lordship. Lordship, it is regarding with item number 38. It's regarding the Joymala elephant, lordship, that was under captive in Chennai, lordship. So we would like to file an IA, lordship, for impeachment, lordship. Lordship, the matter is already in the list as item 38. Lordship, today we have filed the IA. So then, lordship,
Let the matter be called up, then will remain present. Listing will not be possible.
lordship,
To remain present, will see what.
lordship, much obliged.
Wait, please, Lordship. I would like to for mention for listing of our reputation for tomorrow. We filed it on Friday itself. It is regarding a disconnection of electricity connection without any notice. I'm obliged.
I place your lordship. Lordship, prayer for listing lordship tomorrow.
What?
Listing for motion lordship.
What is the matter?
Matter is land related. And this tomorrow.
These are not urgent. Land related means what?
Land dispute lordship.
What dispute? After the
Please, your lordship. I beg to mention item number 27. Lordship, can this matter kindly be taken from other table?
item number 27.
Yes, your lordship.
You are appearing for?
I'm appearing for the petitioner.
What is your name, please?
My name is B.B. Kapoti.
On the request of Mr. B.B. Kapoti, Learned Counsel appearing for the petition. This matter stands adjourned. Let this case be listed again after the upcoming petition.
Obliged.
Please, your lordship. Your lordship, I beg to withdraw item number 1, 2, and 3 only, your lordship. Item number 4, 5, and 6, they have been accidentally listed together, your lordship.
1, 2, and 3 you want to withdraw. Why? Order has been complied with.
Yes, your lordship. As per instructions.
Miss
As no.
S. Newar, Learned Counsel appearing for the petitioner in this case submits that the order of the court has already been complied with and therefore this content case be closed. Mr. R.R. Gogo, Learned Counsel appearing for the respondents is present and confirms the same position. In view of the above, this content case stands closed. Same order we pass to 2 and 3. Yes.
Obliged.
I think 4, 5, 6 is right. Let these matters be segregated from item 1 and listed again in the appropriate column after the vacation.
Obliged.
Fast over.
May I please, your lordship.
Yes.
This particular regarding non-completion lordship 127 1 2022 lordship passed in WBC code 1 4 lordship. 2022 lordship. The relevant portion is lordship page number 5, page number 23 lordship.
This is covered means in what sense?
Yes, lordship. This cover lordship, this authority passed a speaking order lordship. As per speaking order lordship, all the claim will be paid within 6 months lordship. And thereafter, the payment will be processed as per lordship concern lordship. And I have another speaking order lordship as annexure number 3 lordship. Page number 30. Page number 30 lordship in para 5 lordship, married lordship. And Therefore, in view of the above facts and the circumstances, the BTC has decided to verify all such works by conducting comprehensive audit, financial verification, and physical verification wherever applicable against all such contractual works in the above level, and further to complete the whole exercise in this regard within
Mr.
6
Ahmed,
months.
I have understood your case. You want to say that now the BTC has laid down a procedure for payment of outstanding dues.
Yes.
Correct.
Yes,
The learned judges only said this case is covered. There is no direction within how many days, what is to be done. There is no direction.
no, no, sir. Actually, what happened within 6 months, losses is mentioned.
No, no, in the order there is no direction.
As per BTC, in terms of losses, kindly come losses page number 22 losses. 22 losses, last paper losses.
No, Mr. Ahmed, unless you can show me an order of the court which says that follow the guidelines so and so, make the payment within such and such date, how can there be contempt of court?
As
The
per,
learned judges only said that this is covered. That's all. It is covered under the order dated 17/12/2021. Where is the order dated 17/12/2021? On record.
yes, sir, I have, this is the, I have, this order losses to 17/12/2021.
Where is the order? Where is that order?
And my order losses, page number 16 losses.
Where is the order dated 17/12/2021 passed in WPC number 6482?
Yes,
Learned
sir.
judges-
And it's a 5 page number 18 losses.
Annexation?
5 page number 18. From 18 to losses, this is the order losses. Disposed of in terms of the BTC spring water loss.
The order which you are annexing and relying upon, it says nothing except that it is covered under service. That, in that case, it was directed that the claim should be examined and steps should be taken as per circular.
Then it should be within 6 months losses. Yeah. After 6 months, as per contract, normal losses will be put loss.
There is no content of the order.
But it is case number 22, it is mentioned, yes, sir. Last loss. The BTC authority will be verified within 6 months losses. After that, it will proceed loss.
You may have to seek a review of this order. This is not going to help you. Contempt is a very serious issue. You cannot use contempt as a driving force to compel the officers to do something which is not specifically directed. It may be covered, but what is the direction in this case? On the request of Mr. J.U. Ahmed Naik, counsel for the petition, this matter is considered. This case again after upcoming vacation, so as to enable to examine the legal issue arising in this case. You have to examine this and address the court. It is all right. The order has been passed by the learned judge. But the question is, there is no direction here. It only says this is covered by so and so case. In that case, the direction was issued in the facts of that case. In this case, the facts are different. So how can we issue notice for contempt? In principle, it may be covered, but what is the direction in this case?
Dispose of as per the speaking order losses, there is mention. Homelessness.
Yes.
A pleasure. It's relating to
what is the instruction? Notice has not been issued.
Not yet.
Notice will have to be issued. At Mr. Arun Chaudhary, counsel for the petitioner. There will be order dated 25 to constitute this case. Ms. S. Sharma, Lalit Government. Issue notice of meeting since Sharma, who's appearing for me? Mr. Dev Chalya, Lalit Standing Council Finance. Has declared an accepted notice for the. You are for the finance department? No, and Ms. L. Sharma, Lalit Government Advocate Assam is appeared for response numbers 2, 4 and 2, 3, 4 and 5. And Ms. L. Sharma, Lalit Government. 5 and Mr. R.K. Mushad. And it's SCBGC reporting sergeants of Muslims to be completed in this case. Extra copy of the application will be used. So as to enable this.
Next one also same.
Next one also same party also same.
Party is different, but method is same.
Meanwhile, if he has not produced the LOK, he may approach the deputy commissioner with the next of kin. That is not the next. In my opinion.
In the meantime, the petitioner will furnish the case of the old certificate to the concerned authority for processing her claim. Is it? For processing. In item 9, petitioner is male or female?
9
Nine
is
male, yes.
For processing his claim.
then is also
This matter also. Same order. Same order.
Supply.
Council is not there. Take on her Mr. Alex Mishra, Nadi Council. The order dated 23/5/2020. This matter was fixed to the obtaining instruction by the Nadi Study Council. The matter would require further examinations. Issue notice of motion in 6 weeks.
Lots of, lots of, yesterday, probably taken the opening day. Probably will allow
The issue notice.
lots.
When you write, the matter is fixed for the instruction. So, SC file and SC GST submit the instructions and still. 31. So, Mr. Kyle that you are accepting only the response. No. Extra copy of the requisition of the funds, that is a part of the funds. So as to revenue of next again 31 day interim order for study of the patent.
Persons will be fishing in our saddle fishery. We'll also initially complain to the circle officer, then we also complain to the police. And since the police is not taking action, we will represent before the police and also mark the copy of deputy commissioner. The state council was asked to the instruction the last 2-3 occasions which is time.
I have received inspection from the superintendent of police with regard, my lord. Since there was no criminal intimidation, my lord, that FIR was, my lord, false, closed, my lord. This is the inspection received from my lord.
It's outsiders not trespassing into our territory now. Like, whether there is criminal intimidation or not, my lord. Trespass itself, my lord, is the offense, my lord. They have made specific allegation, my lord, they have made creating trouble over the area, my lord. In fact, my lord, earlier the missing of was council have made some settlement. After expiry of that, my lord, these people are taking problems.
So, Mr. Datta, have you seen this?
Single copy, my lord, I have received.
All right. You have a look at it. Your criminal complaint and all is not going to work out. Because just the way you are claiming right to fish, there is someone else who is also claiming right to fish under the say under another order of settlement. So the police says what to do.
In fact,
According to him, you are encroacher, and according to you, he is encroacher.
in fact, there is no settlement settlement. The missing autonomous council is settlement, they cancel the settlement. In then, my lord, in case that case will perhaps.
So what we'll do is we'll issue notice, let them file affidavit, and then thereafter, if you can make out a case, we will ask them to consider your prayer for renewal or extension or whatever.
Since they filed a report, and I have to take corrective action now. I have to challenge this or whatever.
What is the name of the other party? Have you made him respondent here?
No, they are not made respondents, my lord. Because there are different persons who come from different at different time, my lord. But in the subsequent the FIR, my lord, we have not made them name them, my lord.
Now, in view of the report, will you not have to make him a party?
I think that yes,
Huh?
yes. That's,
Then you have to file an impeachment because he is a
yeah,
private party.
yes. Just now with this report, my lord, I have to take necessary steps, my lord, corrective steps or whatever. May I
They have to implement the party respondent.
May I
instead
tell
of-
that this matter is on authentication, that authentication will take the message.
Mr. Additional civil body. Instruction dated
12 September 20.
I see. Some. The result of which was alleged by the petitioner without by another party which claims to be his holder part of the petition. That is the absence of the private respondent. Mr. Datta is for posting this matter again after the petition so as to actually find a petition for the private respondent. This committee for
Worship matter pertains to opening of objection of opening of IMFL shop and lodging. Last occasion, you asked to take instruction as to whether there is any existing IMFL on shop or not. But as per my instruction, there was only one IMFL on shop, but that has been closed for the last since 2010 in lodging. And as far as I'm concerned, lordship, the petitioner, there is no signature office in the representation submitted before the deputy commissioner. Lordship.
We'll have it after vacation. Now it appears to the petitioner on court. Mr. R. Gogol and the Standing Council Excise Department has some service on instruction that there is no other IMFL
On shop, the lordship.
off, you said off shop?
On. He said off, but there is no.
IMFL on shop in the vicinity. And the private respondent has been issued license to operate an IMFL on shop.
Private respondent is allowed to issue off shop, lordship.
Off shop.
Off shop. He's contemplating an off shop, but as per my instruction, there was an on shop which has been closed in 2010 year lordship.
There is no other supplements and there is no other IMFL off shop in that vicinity. And the only IMFL at all within its on shop operating in that area has already been closed. Under the circumstances, the Learning Department of Council submits that, no, before that is right, the petitioner has also not filed any complaint before the deputy commissioner. So under the circumstances, Mr. Gogol submits that his petition is not legal as well as in the facts and circumstances of the case. Be that as it may, since the petitioner's counsel is absent today, this issue cannot be gone into. So registry to therefore list the matter within petition.
Obligations.
If the husband of the petitioner died in water accident, he can notice the law.
Lordship, in this matter, finance department is not made a party, and the next of kin certificate is also not annexed. These two options are not considered by the petitioner.
We will treat the finance party as a party. But Mr. M. Hussain and the council for the petitioner. The wife of the deceased has accused this court. Wife of the deceased who died in a motor accident on 39/10/2020 has accused this court by filing this petition seeking ex gratia relief. This unbodily Learning Standing Council, the Revenue Department submits that the finance has not been included as a party in this case. Moreover, the petitioner has also not produced the NOK certificate. NOK within single quote, sir. Having regard to the nature of relief, this case is of record that the finance department of the municipal party in this case. As such, the secretary to the government of the finance department is hereby included as external. Registered to make the necessary enforcement of the process. We should notice a motion return to the secretary. Since Ms. M. Godwin has declared accepted
Correspond number 1.
And Mr. H. Sharma, Learning Standing Council Finance Department. This matter will be listed again by reflecting the name of all the department of council. Also similar.
Next item also similar defects.
Similar defects, everything is same. Next item is the same.
Only here was
Accident
the
date.
wife of the petitioner is died.
But the accident date is also not same.
Accident date, what is the accident date?
24th of October 2018.
And it is the husband who has come.
Yes,
Husband has come.
Husband, the husband of the deceased.
Public.
I'm obliged to motion.
Where is the name shown here? Standing Council of Industry.
It's about
What the case about is that, in the industrial area, in Badarpur Ghat Miller, a particular portion of land has been allotted to the petitioner for opening of his soap industry as a popular soap industry by the Small Industries Development Corporation. And to that effect, an agreement has also been executed. Now, my lord, may be pleased to find the agreement is at page 22, and this agreement is long back, on 5th of March 2017. So, till date, the position has not yet been handed over.
Lordship, we haven't received any file.
The-
There is a representation 29/11/70, 23/3/2022.
Now, the 2911 is at page 41, annexure 6.
23.
No, it is 29/11/2017. Annexure 6 at page 41. Can be also taken, disposed of.
So have you paid any rent? Any
Yes,
deposit?
after the execution, the bill, my lord, may be pleased to find is at page, P 38,
Mr. Bhuya, you have two options.
my lord,
Go and come back again
my lord,
after your representation is rejected,
my lord.
or let the court examine it by issuing notice. Choose the option you want.
Lord, representation can be-
If you want to come file the second case, it's good for you. I know.
my lord.
If they have not given you the shed for so many years, they will definitely not give it to you now.
And my lord, may issue notice.
Oh, I understand. Additionally, I agree that non-consideration of his request allotment of an industrial space at Badarpur for establishing a soap manufacturing unit. Soap manufacturing unit.
My lord, my lord.
Mr. Bhuya submits that despite the approval granted by the district level standing advisory committee, asking the petitioner to execute the lease agreement within 30 days. Pursuant to which the lease bid was entered into on 5/3/2017. 5/3/2017 for a period of 10 years. The space has not yet been allotted to the petitioner. Thanks to the petition. The Valley Standing Council of Industrial Department brings for instruction in the issue notice of motion returning in 6 weeks. Since who is appearing for him?
Mr. A. Kalita, Standing Council of Industry and Commerce.
Mr. Kalita, Standing Council Industrial Department. Accepting notice on behalf of
My lord, 1, 2, 3, 6, and 7, my lord.
1, 2, 3, 6, and 7. And Mr. D.K. Sharma, Limits, Additional Civil Government. 4 and 5. Service and notice of extra copy of the information by requisiting numbers by furnished to the learning department of council so as to enable them to obtain instruction facilitating disposal of information. It is also made clear that tendency of this petition shall not be a bar to the respondents to redress the grievance of the petitioner in accordance with law if so advised.
Obliged.
Government has to take this.
Sometime they can leave the content. There's no strike. Why is my lord time? Why time is being done?
Communicated, my lord, copy and receipt. So actually, it takes it immediately after the petition. Definitely.
So are you allowing anyone else to give the materials in the meantime, Mr. Mohanty?
No.
So when you issue notice and direct that the scrap materials lying as it is shall be protected, shall not be, it cannot be taken during the vacation. It has to be after the vacation. So what is, you know everything. You want to come during vacation?
No.
Then we have to fix it after vacation.
After seconds only, my lord.
In this case, you can't get an interim order, you have to get a final order.
Yeah, notice, motion stay, my lord, is
You fix it. Have it fixed on 1st November. If they want to file affidavit by 26th October, they can file. In 5 years, December, we'll take it up to disposal of the motion stage, they are not bound to appeal instruction. But sometimes we give them time so that the problem can be solved. Motion instruction is for problem solving.
Here,
And,
actually, the case was.
That it shows that they don't want to solve the problem. The court has to give an order. That cannot be done in motion. I had Mr. James Ireland and senior counsel at State Bank.
HK sir.
HK Sharma, counsel for the information. Also have Mr. P.D. Appearing on behalf of Mr. D.K. Sharma and appearing for the respondent. Instructions in terms of order dated 14 March 2022. Same is received. On the other hand, Mr. Simon has expressed urgency in the matter of delay this matter is causing serious prejudice to the interest of his client. As such, an interim order was passed protecting the interest of the petitioner. Having heard the argument of the counsel for both persons, this court is of the opinion that the matter is expeditious disposal based on precedent. That such issue notice for motion 1/11/2022 sees Mr. Sharma has appeared and accepted the and who is assisting you, Mr. Mountain? And Ms. P. Mountain, report to the assistant. Ms. P. Mountain has accepted motions for external 2, 4, and 5. Charges and notices deemed to be completed. No, what about the 6? Number 6?
Maybe start off, I think, my lord, this is only the formal party, my lord, performance.
Charges and notices are about on the request of Mr. Since the so accepted notice. I will submit the response number 6 has been included as a formal party and therefore the name of the said respondent is structured from there. Fair enough. Name of response number 6 is here by structured. Registry to make necessary adjustment. In view of the above, this repetition is deemed to be complete with regard service. The respondents are granted time till 26th of November, 26th of October 2022. Bring their stand on record by filing affidavit. Mr. The petitioner may file rejoinder thereafter. If so advised, this petition will be listed beginning on 1/11/2022 as a fixed item. The matter will be taken up for disposal at this time. Parties to come prepared accordingly.
Instead of 26, it will be 27 because my lord, 24 and 25 is already 27.
27.
Obliged.
Then we'll have it on 2nd November. You may also need some list on 2nd November. Available on 2nd November.
May please, Your Lordship. In this case, instruction was sought for Your Lordship.
I have not received any inspection. In spite of communication with my lord.
Then we'll issue notice to maintain status quo till the next week. So third Mr. has brought up the council for the petition. And there will be amendments given to the petition. Apprehending eviction from the landlords under their occupation. The petitioner will approve this for public minister. By the order dated 21/9/2022, the government advocate was asked to approve instruction in the matter of Mr. However, either when the matter is called, Mr. D.K. Sharma, additional senior government advocate, concerning submit that instructions are still awaited. In view of the other issue, notice of motion beginning on 7/11/2022, since Ms. M. Gautam, Linux,
Correspondent number 1.
the Revenue Department has appeared in its Mr. Sharma, additional senior government advocate, concerning accepted notice. No foreign notice is required in sending extra copy of the petition reference to the department. This case again on 7/11/2022, next item, the hard repair of insurance, considering the facts and circumstances of the case, is hereby provided that status quo as regard to land under the occupation of the petitioner shall be maintained till the next date.
Yes, Your
As of today. Status quo as in as of.
Lordship.
Instruction was called for. However, there is a good news, I think. A letter was issued by the circle officer to the deputy commissioner saying that the resurvey will be conducted tomorrow. Letter received by me yesterday. Actually, I prayed for resurvey of my land acquired under the national highway. And my prayer is already covered in this reference letter. But only thing is that this type of letter has been issued earlier twice. I don't know whether it will be done tomorrow or not. So till that, till the survey is done, I will be protected.
What protection you want?
Actually, the thing is that one of my plot of land has been acquired, 1.67 lesser. But when they mark the ROW, that right of way, it is far beyond, almost 8.5 lesser. Either they have to acquire 1.67 lesser, or they have to give me the full amount. So therefore, I paid for one resurvey of their land, and earlier twice the additional deputy commissioner directed the circle officer to resurvey the letter. My lord may peruse those letters. Direction to the circle officer at page number 18, madam, where the director directed, page number 18, annexure 4.
So what is the interim order you are seeking?
Till the resurvey is done or proper report is done, whether my land is 1.67 or 8.75, the possession cannot be obtained by the authority, because if once the possession is obtained, there are wall and some other things also that cannot be measured.
Joint orientation must be signed by both sides. Your client will not sign something which is not acceptable to him or her.
The problem is that, my lord, they are warning that either you give me the possession, otherwise I will take it with the help of police, etc. Now, if I go through the national highway, the exact amount of land, that is 1.67 lecha, that they are entitled to take possession. But the thing is that they have marked the ROW line far beyond. Now, when they will come to take the possession, they will go that line. Otherwise, that total land is not measured by the or resurveyed by the going.
But you can't get into all these things. They are free to take any land they want. Only thing is they will have to pay you compensation.
No, they have to, before that they have to take the
All right, they
notification.
complete joint measurement and prepare a report.
If
Thereafter-
tomorrow it is done, I have no problem. But the thing is that earlier twice, my lord may.
Oh, forget the earlier part.
My lord.
Now,
But the thing is that if it is not done tomorrow, and day after tomorrow, they come and take my position, but their protection I need, nothing else.
Tomorrow the re-verification is going to take place. And thing is that what he is saying, he is the Giraffe holder or the this thing of a title holder of a editor. So he
I had heard Mr. Deacon learned counsel for the petitioner. The authorities are proposing to take over some portion of the land owned by the petitioner for the purpose of construction of a road by the NHI DCF system. The primary grievance of the petitioner is that the respondents are proposing to take over possession of the land without carrying out joint verification of the land. Mr. Nath submits that the respondents are seeking to occupy more area of land than what has been earmarked, and that too without carrying out joint verification. Therefore, an order be passed not to take over possession of the land before completing the joint verification and preparation of report. On 23/9/2022, this matter was adjourned so as to enable the land and government administrative Assam to obtain instruction. So today, when the matter is called up, a copy of the notification dated 26/9/2020. This is 2021.
he is producing it.
I have been given yesterday. That is 26 September. I think actually it was given yesterday.
Now see, our instruction.
No, my lord, kindly come to reference. Actually, it is typological mistake. Come to the reference file.
2022.
Yes.
Wrongly shown as
Yes, yes.
2021.
Yesterday it was.
2021 bracket 2. A perusal of which goes to show that the joint verification of the land, joint survey of the land has been fixed tomorrow, that is 29/9/2022. Mr. Sikya Buru, Grand Government Advocate Assam and also confirmed the same information. In view of the above, issue notice and motion and return to 14/11/2022 since while notice will dispose it of.
You can do it.
If that is so, nothing further survives for adjudication in this case. Mr. Sukyas Bora, Lions Government Advocate Assam, appearing for the respondent numbers 234, and Mr. R.K. Talukdar, Lions Council for the respondent numbers 5 and 6, have also agreed to the same proposition. As such, with the consent of Lions Council for both the parties, this petition will be disposed of by providing that the respondents shall not take over possession of the land of the petition before completion of joint survey and preparation of report under by following the due process of law.
That copy may be given to you.
Huh?
That copy may be given to you. So
Copy of the report be furnished to the petitioner before the possession of the land is taken. This petition stands disposed.
Lordship. In this case, the petitioner's land was acquired by the original Deputy Commissioner Revenue Bongaigaon, for the purpose of the expansion of the national highway, without any survey, without raising any LA case. So earlier also, your Lordship, a similar case, the notice was issued, my lord.
You should notice that Mr. KC Royal Living Council for the petition. The grievance of the petitioner is that the authorities are seeking to take over possession of his land for construction for widening oblique improvement of highway at the Columbia Jogipapa Bridge approach section without carrying out proper survey of the land. The Land Departmental Council appearing in this case pray for some time to obtain instruction to that. And within 6 weeks, Who is appearing for whom?
Lordship, I am for respondent number 1.
This N. Bordele, Level Standing Council, Revenue Department accepts notice for respondent number 1. This, Learned Council. You are standing council. NHIDCL accepts notice for respondent numbers 2 and 3. Mr. Sequence Guru, Learning Government Education accepts notice on the respondent numbers 6. As such, service and notice is deemed to be complete in this case. Extra copies of the petition will be furnished to the learning department of council so as to enable them to obtain instruction. Let this case be listed along with
my lord, WPC number, my lord, 5023 of 2022.
yes.
Obliged.
What's the matter?
Next, Your Lordship.
You are NHIDCL council. This case in DLC.
Next, Your Lordship, Your Lordship, kindly pass over the matter for time being.
Lordship, I have come to your honor against the order dated 15/6/2022, by which the penalties were imposed upon the student. I am a student, MTech student in the IIT Guwahati, and further I also have a startup by the name Agri Vision for You. So the brief fact which I want to tell before your lordship is that the main reason why show cause notice was issued against me was the reason because of a simple email. I will take the lordship to page number 37 of the petition.
What is the matter about? Can you tell us?
The matter is basically about an email which I have a startup with the name Agri Vision for You, where I give agriculture education and knowledge processing. So thereafter, what is the issue is like I am also a student of IIT Guwahati pursuing my MTech from IIT Guwahati. So by one email I have sent to my students, and in that email I have used the logo of IIT. It was an inadvertent mistake on my part, which I have accepted. And so for that, the main contention, I was issued a show cause notice. In the show cause notice, various sets of allegations were leveled against me. The main allegation was the email. That's the one email which I have sent across by using the logo.
So for saying what?
Show cause saying that I have been used that logo. I have been charging money from the students for the purpose of this for my startups, and the different sets. And one more allegation was the plagiarism, which I was given F grade by the Jifu University. So these are a few sets of allegations which was labeled against me. Against the show cause notice, I have filed my reply by within the time frame, and in my reply, I have given a detailed explanation till date along with my accounts and audited accounts of my. I have given my personal account details, and along with that, I have submitted an audited accounts of my firm, that I have not taken any money from the students. And if I take your honor to the main email dated
This matter is educational matter. This is not a bench for case.
yes,
This should go before the appropriate bench. I take heard Mr. F. Faridi, Learned Council for the petition.
F for you.
F. Faridi, Learned Council for the petition. Also heard Mr.
AB Day,
Mr. A.B. Day, Learned Council appearing for the
IIT, for all the
IIT
respondents.
Guwahati. The petitioner hearing is a student of IIT Guwahati. Mr. Agreed by imposition of penalty
Yes.
upon him due to alleged misconduct.
Yes.
The petitioner will approach this to. After going through the pleadings in the petition, it primarily appears that this is an educational matter and therefore should be listed before the appropriate bench. In view of the ensuing vacation, the registry is directed to examine the matter and list this case before appropriate bench by tomorrow.
Yes, sir.
Much obliged.
Which is the matter relates to non-payment of contractual bill matter. Where the total bill amount is matter 15,25,000.
This matter relates to non-payment of contractual bills which according to the applicant. Third, Mr. A. Hassan, learned counsel for the petitioner. Ms. J. Gogoi, learned standing counsel, water resources department. Waits for some time to action in the matter. Anyone 6 weeks, since Ms. Gogoi is actually accepting notice. 1 to 5. All the respondents.
All
Hence, no formal notice. Extra dependence, etc.
Obliged.
Please, relating to the calls to stop minor, calls like stop minor, I think less than 50% part holder minor. Similar matter has been under lawsuit hard minor and posted of the fixed. Which is the similar order? Order in case? Yes, case 36, my lord. So your fair price shop license is registered today. Yes, no, my lord. My fair price license number, page number 20, my lord. I renewed, my lord, up to my lord 2022 March, my lord. Before March, they stopped my. So what is the order you want now? My lord, my lord, director, my lord, issued a letter. My lord. What is the order you want today? My lord, the similar order, my lord. What is the similar order? There are two. How can it be done? Your license has not been released. See, this is the problem you will face in this court. Let me tell you this. Similar order will go on. But the order passed by this court at the beginning was at a stage when the licenses were valid. This is going on. But in this court, these queries you will face. Your license is expired. How can you now run the shop? I know they have not used my license. Correct. We have the letter issued by the director. You cannot answer the question. You know the answer. Now, once the license is expired, you cannot run the franchise shop. As simple as that. Director maybe my license. Great, sir. Great, sir. Mr. Athiya, you are a counsel. Tell us, in the motion stage, can a final order be passed to renew your? You argue if you say it can be passed, I'll consider. You don't want the interim order. But you know it is not permissible. So this court will only pass orders which is permissible. Don't show me orders here and there. Show me orders, you convince me that this order is correct according to law. Only because of the letter, my lord. The letter, my lord, page, my lord. 26, my lord. Yes, 26. You can argue. I am not stopping you from arguing. My lord, 26, my lord. Director of Food, Civil Supply and Consumer Affairs, my lord. Yes. Issued letter to the Principal Secretary, DPSC, Rina Hoffa, Karbi Anand, all deputy commissioners, except 6 city areas, all sub-divisional officers, except 6 city areas. My lord, taking of ration cards from Mr. You see, the court is aware that you know what is the question and you may not be able to answer. But still, For interest of justice, I am putting it again. There are a large number of cases pending in this court now, where interim orders to the effect that no coercive step is to be taken is operating. Those orders initially were passed at a stage when the FPS shops were being operated on the basis of a valid license. Thereafter, orders have been passed by honorable judges on the request of counsel, similar order, no coercive action. After the licenses have expired, nobody was allowed to operate the shop, so this no coercive action is a meaningless order. Today also you are asking for that order when your client's licenses expire. Renewal of a license is one thing, and tagging the customers to another and stopping it by an interim order is another thing. If you do not have your license renewed, until and unless you finally succeed in the petition, how can you operate the fair trade shop? That is what I am asking you. Then what interim order you are seeking today? Council for the petition. There is the amendment going to the petition. It appears that similar petitions are pending before this court in large numbers where the same question of law. That is, i.e., whether the decision of the government to detach consumers from FPS shops having less than 50 customers and attaching them to the nearby FPS shop is valid in the eye of law. It appears that the FPS license issued to the petitioner has already expired in the month of March 2022, and thereafter the same has not been renewed. Be that as it may, since similar petitions are pending, this matter would also have to be examined. Issue notice of motion returnable in 4 weeks since Mr. CPS Boria learned government everywhere Assam and appeared and accepted notice on behalf of all the respondents. No formal notice is required in single case. Extra copy of the petition be furnished to the Government Department of Council. Requisite numbers so as to enable you to obtain instructions. Let this petition be listed along with. Can you give the number?
Yes. 13 case is minor 5470
Application number 5470 and 2000
2021.
21 and the connected read
And
petition.
connected.
Yes. If you succeed in the read petition, you will get a direction to renew. You have to wait till then.
I have to modify my.
Probably. Because what happens is these are done mechanically.
Yes.
Mechanically doing things create big problem later on. So this is not how the courts can function. Courts will have to pass orders on facts in each case. Correct. So you examine your petition, and if you need to amend it, do it. Otherwise, it will create more problem. Yes. Yes, please.
The negation case for the national there is some wrong in the pata number. Initially, section 3A, my land is and pata number is wrong. That number is come. Subsequently, 3 is on my one was not reflected. And subsequently, number Allah for resurvey. My name and land is included.
How much land? 13 bighas.
13 because whole land is 13 because.
How much they are seeking to acquire?
Because 1.1607 hectare.
They want to acquire 1607 hectares.
0.1606 hectare.
0.160.
07. This approximately
But there is a incorrect reflection of that number, pata number in the
that number is same. Pata number is
incorrect where?
in Excel 5.
What is it? Annexure 5 is
Not Kala, the joint secretary, wrote to the general manager development authority.
no, there is a notification issued under section 3. In that notification, is the tag number correct?
That number is correct. Pata number is wrong. It says it is reflected in.
So then we'll issue notice. I heard Mr. P.S. Dekal, senior counsel, instead by Mr.
BS.
You also feel that.
Yes, yes.
Yes,
Yeah,
and yes, because like a council appearing for the petitioner, the respondents are proposing to acquire the land belonging to the petitioner measuring about 0.1607 hectare situated in the district of Kardianla. The grievance of the petitioner is that although the DUG number has been correctly reflected, the patta number pertaining to the petitioner's land has been wrongly projected in the notification issued under section 3 of the, which is the act?
Capital A,
K,
3A of
K
the
of the
National Highway Act 1956.
National Highways Act 1956, hence the petition. First of all, the Land Departmental Council has paid for some time to obtain instruction of the matter. Issue notice of motion to return on the 6 weeks. Since who is appearing for 1, 2, and 3? You are appearing for 1, 2. Since Ms. R. Devi Lanet CPC has accepted notice for respond number 1, Mr. A. Borrow for respond number, R. Borrow for respond number 2, Mr. R. K. Talukdar for respond number 3, 4, 5, and Mr.
6, 7, and 8.
Chitia Lanet standing council KAC for 6, 7, and 8. Service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the Land Departmental Council, requisite in numbers, so as to enable them to obtain instruction in the matter. It is made clear that pendency of this writ petition shall not be a bar for the respondents to take corrective measures in this case, if so advised.
The petition may be directed to furnish the mallet, original copy of Porta before the Kala mallet.
In the meantime, the petitioner is granted liberty to produce original copies pertaining to the land, original copies of the land document before the
Porta.
land document including patta, PATT,
Before the respond number 7.
respond number 7, so as to enable him to do the needful. Yes, please.
Met with the worship. Worship, in this case, the petitioners applied for the benefit of Pradhan Mantri Gram Awas Yojana, your worship. Pradhan Mantri Awas Yojana, Gramin worship. Their petitions were not considered worship, and thereafter annexure 1 list was prepared, your worship, taking some people who have already allotted house worship second time, third time worship, and some persons who have already pakka houses, they were also, their name are also in the list worship. So we find representations annexure 2 and
So let her obtain instruction then.
lordship.
Third
Till then,
Mrs.
lordship,
Till then what?
till then, lordship, some protection, lordship.
What protection? If you
That
succeed, we will ask them to provide it to you.
Lordship,
What
that-
has it got to ask with some other person?
lordship.
Yes, but you will have to obtain instruction within 6 weeks. File affidavit. We will not delay these matters. It creates more complication. Third, Mrs. R. Chaudhary, Landed Council appearing for the petitioners. The petitioners herein claim to be entitled to the benefits available under the Pradhan Mantri Awas Yojana Gramin bracket PMAYG bracket close scheme. They had all accordingly applied for such benefit. However, in the final list of beneficiaries pertaining to the Hainakandi district
Yes,
was published, the names of the petitioners did not find place therein. According to the petitioners, although they were eligible, their names have been arbitrarily dropped from the list of list of beneficiaries, whereas many other persons who already have permanent housing in the district have been included in the same list. Ms.
And Bora.
N. Bora Lanet, Standing Council, PNRD Department, Assam, has paid for some time to obtain instruction in the matter. First, issue notice of motion retirable in 6 weeks. Since Ms. Bora has appeared and accepted notice for respond numbers
1, 2, 3, 5, 6, and 8.
1, 2, 3, 5, 6, and 8. Mr. B. Berry for respond numbers 4. And for respond number 4, as new formal notice is required to be sent to the respond number 1 to 6 and 8. Extra copies of the petition be furnished to the Learning Department Council, requisite in numbers, so as to enable them to obtain instruction. Stop petitioner to take steps for service of notice upon respond number 7. But register comes to reading within a week from today. Considering the nature of controversy involved in this petition, the respondent numbers. The official respondents are directed to bring their stand on record by filing affidavit on or before the returnable date.
The pendency of the expedition will not be.
They will not give you, will pass an order.
Yes.
Well, this is a service letter. Probably it has been as a residual subject lordship, it has been put before the lordship. Well, the petitioner has been terminated without any notice, without charges, anything. Simply terminated, I want another person there.
Service matter before this went why?
That I find probably residual matters maybe other death problem it has been given. So,
Srimanto Sankadev Sanghat Thrift is a
chips of
government.
the cooperative society.
No, Lordship, I have spoken to the department officers, the private society matter. So we have formal party here.
Shipton Credit Cooperative Society. This is under the Srimanto Sankadev Sangha, which is also registered. society. This is a registered society, Shipton Credit Cooperative Society. This I am an employee of that society. And they have terminated me without giving any so-called, without making any inquiry. And it was on 12/7/2022, page 94, Lordship may find the termination order. They put me under suspension without any, nothing has been paid to me also. And ultimately, unfortunately, meanwhile, they have appointed another person against that. So notice to go now for the time.
But is the rate maintainable in this?
Well, the cooperative society is registered, yes, it's maintainable. Our court decision of the court decided.
Lordship, may issue the maintenance is open.
Yeah, state should be the meaning of Article 12.
Cooperative society.
Yes.
For the Lordship, Lordship have to examine their bylaws.
All right, for now, we'll issue notice of
Fine.
Mr. K.K. Mohammed, Senior Counsel, assisted by Ms. N. Begum, Learned Counsel for the petitioner. Agreed by the order of termination from service, the petitioner has approved this court interior contending that the order was passed without framing any charge against the petitioner or giving him an opportunity of being heard in the matter. I feel the otherwise made in the petition. Issue notice of motion returnable on 16th of November 2022. MD Bora, Standing Council, Corporation Department
For
has
6 and 7.
accepted notice on their response number 6 and 7. Extra copy of the petition be furnished to Ms. Bora. Petitioner takes the service of notice upon filed by Minister Post with Delhi within 3 days from today. Since Ms. Bora has raised the question of maintainability of the petition, the same issue is kept open and shall be gone into a distinct admission.
I am deeply obliged.
Appointment of this respondent number by 4, no? 4.
It will always be subject to
Subject to result.
It will always be
Completely look at that.
the
Obliged.
appointment of the respondent number 4 in case of the petitioner is subject to further orders that will pass in this case.
Deeply obliged.
Please, Lordship. Lordship, petitioners post for us where the Khatian holders, Khatian number 173 of Village Kakhaldi Part 2, Lordship, under the subdivision of Bilasipara. In the month of August 2022, the concerned Lot Mandal surveyed the land, Lordship, and verbally informed the petitioner to vacate the land, Lordship. And attending of eviction, Lordship,
Where are documents of your title?
Lordship. Lordship, page number 16, Lordship.
Number 16.
Lordship.
translated.
These are not
version,
legible.
Page
Translation,
15.
page 15, Lordship.
Who is this person? Danish Ali Sheikh, Maher Ali Sheikh. How are they related to the petitioner?
Lordship, he, it was led under Zamindar system, Lordship. And the petitioner's forefathers were the Indians under him, Lordship. Under this Danesh
So
Ali,
who, there are 18 people who are in the petition, 19.
Lordship.
All of them don't have these documents.
Yes, sir.
Lordship,
We may be open to protecting persons who have some documents to show that their possession was not as encroachers. See, the principle is very simple.
Lordship.
You come to the court showing that your possession is not as an encroacher, you may or may not have a title. We'll ask them to serve notice. If you do not show it anything, we are not going to interfere.
Lordship, page number 1892 in the order revenue tax repayment receipt, Lordship.
Page number?
18, Lordship. Yes, 18, 20.
By whom? That's what we are asking. Which person?
Lordship,
You clubbed everyone together. Now you will tell the music.
Lordship, page 17, the family tree, Lordship.
These 19 people are from the same family.
Lordship.
Where are these people?
Lordship, in page number 17, Lordship.
Page number
17, Lordship.
17 is not a statement.
It's a family tree, Lordship. Lordship,
Can't help it.
kindly go to page number 52, Lordship. Order in the WBC 400.
Mr. What is your name?
MH Soikia, Lordship.
Which
In similar situated village, Lordship, nearby village, Dishonorable Court passed this order, Lordship.
order? Let us see.
WBC 400
Page 52.
page 52, Lordship.
So, Mr. Saitya, in that case, there were documents to show
Yes,
that
sir.
the petitioners are occupying the land not as encroachers, either as permissive occupiers or by paying fine or something.
Lordship.
You show us materials for the petitioners, immediately we'll pass a status quo and
Lordship.
ask them to evict you only after servicing notice.
Lordship, page number 18 to page number 30, 35, 36 are the tax paying receipt, Lordship. And page number 15 is the 30 Lordship.
One by one, show which petitioner number 1. What is the document?
Petition number 1.
So we'll go through it and tell us after some time.
Lordship.
You have to give me
Lordship.
show documents of each of the petitioners. Once you show documents, they will only be protected. No others. Yes. None appears for the petitioner on court. Even on second term, the petitioner's counsel was action given on previous petition. This will be after the petition.
Petitioner in this case is agreed by the non-assessment of the damages caused by doing the mallet. Well, laying the mallet.
Power lines.
Power line.
Damage caused to what?
Damage caused to property mallet.
Lamps.
Tea gardens,
Giraffe.
etc. mallet. There is no proper assessment of that.
Like the Mr. You should notice that this thing, Mr. Producer, according to the petitioner, extensive damage was caused to the properties, to his properties, while laying overhead high voltage transmission line crossing the land of the petitioner by the Power Grid Corporation Limited. agreed by failure on the part of the authorities to make assessment of the damage, the petition has been filed. Mr. Ms. Ann Bottomley, Standing Council,
Respond number 1.
Relief and Disaster Management. Mr. R.K.
3 and 4, Lordship.
of India,
3 and 4.
Private Corporation of India.
Yes, Lordship.
Six weeks time. SEEKS 6, then SIX 6 weeks time to obtain instruction in the matter. Where allowed January 6 weeks, since Ms. Bottomley has accepted notice for respondent number 1, Mr. B. Devi and Government Advocate Assam for respondent number 2, and Mr. R. Talukdar for respondent number 4. Service on notice is deemed to be complete. Extra copy to be furnished to the Learning Department of Council so as to enable them to obtain instruction.
Lordship, as regard Lordship, as per Telegraph Act, Lordship, land was acquisition as per Telegraph, and Lordship, if any dispute or insufficiency of compensation, you have to approach the district judge.
Lordship, I pray for reflecting SC revenue.
Let this matter be listed by reflecting the name of respondents council.
I will just have the copy of it.
All right.
My lord, I was related to obtain instruction. I have received instruction, my lord. And everything has been done, my lord, transparently, fairly, my lord. His case is that the private respondent number 4 was given the contract to his exclusion. But my lord, the record will show that his case was also considered, but he ranked lower. And that's why he was not within the. So what it kind of comes to the second page, we have also to find NIP requirement 32 vehicles.
Page number?
The second page, 2, 1, 2, 3, the second chart, 1, 2, 3, 4, 5th column, my lord, revised NIP requirement, 22 and 10. Total 32. That was the requirement. And if your lordship kindly comes to the next page, your lordship will find, my lord, the general category allocation at L1 rate in lot 1. Your lordship will find, my lord, in the chart ranking. So his rank is, my lord, L1I at serial number 10. Whereas the, my lord, respondent number 4 figures at serial number 7. And my lord, at that stage, my lord, 36 vehicles, 32 vehicles that requirement referred vehicles were complete at my lord, serial number 7. So here, okay, the respondent number 4, whether he cannot participate in the tender process. That is my case, lordship. And here, lordship, only go to page number 29.
All right, Mr. Sharma, what happens is we can't set aside the order without serving notice upon the private respondent.
Lordship.
So at this stage, we can issue notice on both main and interim care.
Lordship.
Let him appear in.
Lordship, in the meantime, let them not.
How will you benefit?
Lordship, because each work order is being issued, Lordship, for 10 trucks, Lordship. Here, Lordship, there is a serious violation of contravention of their own tender commission in case of part.
So we'll set it aside. It turns out after he comes and appears. We'll set it aside. Right now, staying means you're not going to get the work.
Lordship, we should,
All
Lordship.
right, Mr. Fisher will have a council appearing for the assuming the selection of the respondent number 4 for award of the contract. Instant requisition of the file internally containing that the respondent number 4 does not meet the eligibility norms prescribed by the NIT, and therefore he could not have been selected as the successful bidder. Also, taking note of the plea raised in the requisition, this court had passed order dated 26/2022 requesting Mr. M.K. Chaudhary and its senior counsel preparing for the IOC to obtain instruction. Today, when the matter is called up, Mr. Chaudhary has produced certain documents to submit that both the petitioner as well as the respondent number 4 were eligible to participate in the tender process, and the bids submitted by both the parties have been properly considered by the tender committee, and after a transparent process adopted in evaluation of the bid, it turned out that the respondent number 4 had scored more marks than the petitioner. Hence, the respondent number 4 has been chosen as the successful bidder. Mr. Sharma, Learned Counsel for the lead petitioner, has however strongly refuted the said arguments by submitting that the respondent number 4 did not offer the vehicles in the requisite proportion as prescribed by the NIT. Mr. Sharma has therefore paid for an interim order restraining the respondents from issuing any work order. After hearing the submissions of both the sides and on revision of the materials and record, this court is of the opinion that the dispute raised in the petition will call for further examination. As such, issue notice of motion determinable on 4/11/2022, since Mr. P. Bharatbhai, Learned Counsel, assisting the senior counsel for the IOCL, has appeared in rules for one. Mr. J. Sekhar, Learned CBC, has accepted notice for respondent number 1, and Mr. P. Bharatbhai has appeared to respondent number 2. No further notice is required to send to the said respondent. However, assisted both. However, extra copy should be furnished to the Learned Department. Petitioner to take steps for service of notice of the respondent by registered to 18 as well as usual process within a week from today. Third declare of interim delay. The suit granted. It is, however, made clear that work order, if any, issued in favor of the respondent number 4 shall be subject to further orders as may pass in this case. The respondents 2 and 3 will also ensure that the respondent number 4 satisfies all the tender conditions before issuing the work order.
I get fair lordship, and maybe I have to correct some, some mistakes is being the repetition lordship, there is a small mistake. I will provide.
You can't correct things like this. It's not permissible.
Lordship, I will file IAS.
Let us see what happens. You can't just write things like this in a pending High Court matter.
Lordship, I will file IAS.
Yeah, please. What's it here to the challenging an order passed by the Secretary and Chairman of the Cooperative Society? I have prepared an application before the Register of Cooperatives under Section 92 and 93 of the Cooperative Societies Act. So that I have filed on 25/8/22, but they have not yet considered my.
File a representation. Where is it?
Appeal Lordship, Annex 6, page 28.
It's 28. Well, I have prepared an application under Section 92 and 93 of the Assam Cooperative Societies Act. But that order has been passed without hearing me, madam, and that as we said, order will be here. I have prepared this application on 25/8/2022. This one they have not yet considered, madam.
Where is the order?
Order is at page of the 23. It translated one. I was appointed on 31/3/22 to collect revenue from the certain portion of.
What do you have to say, boy?
Lordship, appeal is pending. As per section 92 of the proposal, we have filed the application. So is that a good way?
Let the appeal be disposed of.
Application is not a case, but application is disposed of within a period of 15 days. In general, the order is the same.
But Mr. Vijay Sankya, Learned Counsel for the Lead Petitioner, also has his MD Royal and Standing Counsel Corporation Department. For the official respondents.
1 and 2, my lord.
Respondent number 1 and 2. The petitioner hearing was temporarily entrusted with the job of collection of revenue part of the fisheries by the Brahmaputra and Kaveri Cooperative Society Limited
For a period of 1 year,
for a period of 1 year by the order dated
31/3/22.
31/3/2022. And the petitioner was discharging his duty by collecting revenue from the fisheries. The interim order dated 10/8/2022 was issued by the Secretary of the Society.
Secretary and chairman both have signed it.
Chairman come, same person.
No, same, not same.
The order shows on the secretary. Why are you saying secretary and chairman? Sri Shankardev Das is chairman or secretary?
The secretary.
Why are you saying chairman? Secretary of the society, removing him about task and appointing Sri Subhash Das to temporarily collect tax in case of the petitioner. According to the petitioner, the interim order was issued without giving him opportunity of being heard and without submitting proper super notice. They have submitted an application under section 92 of the Assam Cooperative Society 92, where with section 93 of the Assam Cooperative Societies Act 2007 before the submitted it before the register. That is the response number. Here. On when did you submit it? On
25/8/22.
25/8/2022. However, no action has been taken on the same application. For us, submit that since the application filed by the petitioner is pending before the response number 2, this lead petition by providing that the application Sankhya has also agreed to such a request. Beside the application submitted by the petitioner on 35/8/2022, either by himself or through his nominee, or by the permissible other, within a period of 4 weeks. A certified copy of this order.
I'm deeply obliged. Obliged.
Also, the petitioner also has challenged the election of the custom number 5 as ward commissioner from Can appeared in municipal board on 2 counts. Firstly, also as per the election notification, the candidate should submit the education certificate along with the nomination. Although she has made a
Regulation notice at this stage. You can't be a stay of the law. As Mr. Excavator will consider. There will be abundance of by filing this petition, the petitioner has challenged the election of respondent number 5 as the chairman of the
as ward commissioner
of Equatorial Municipal Board.
ward member.
Issue notice returned within 6 weeks since this government applicant Assam has appeared and accepted notice for respondent number
1 and 3.
and rules for the number 2 and Mr. R. Dubey, Standing Council, State Election Commission for respondent number 3, service on notice on respondent number 1, 2, and 3. Extra copy to notification to service to other part of the council. Petitioner takes steps to service on notice upon respondent by registered court to review as well as legal process. That is matter to listed again by reflecting respondent's council and the parties.
Alright.
No applicable lordship. My lordship, in this situation, I have challenged the company of meeting with the deputy commissioner on 29th, which is tomorrow, against me. I am president of the Narayan Singh Gram Panchayat. My first contention is that the section 15.2 and section 15.1 of the company followed, my lord. As per section 15.2, it is mandatory provision. Requisition notice should be submitted to the president, my lordship. The as per Assam Panchayat Act, I may be allowed to read the section 15.2. my lord.
That section is known. We'll ask you to find.
May I please, Lordship? Lordship, due to the flood situation, my lord, that requisition meeting was delayed, my lord, deferred, my lord. Thereafter, Lordship may kindly come to page number 27, my lord. The members have filed this case, my lord. That already flood situation is over, but meeting is not holding, my lord. Thereafter, Lordship had passed page number 28. Lordship may kindly come to next page. Thereafter, only page 29 improvement order was passed, my lord, by the deputy commissioner. Copy was served to him, my lord. Serial number 6.
We'll have this matter on day after tomorrow. We'll tell
My
us.
lord, Lordship had tracked this matter with 508022, my lord.
No, let's have it on day after tomorrow.
My lord.
Not Mr. Abdul Askul Ali Council for the petition.
Well, tomorrow is the meeting.
Huh?
Tomorrow is the meeting.
Tomorrow meeting will go ahead.
My lord,
Meeting is not suspended. We'll clarify.
Right.
Meeting, already the court has asked them to convene the meeting.
my lord,
Question that
as per section 15.1, the code has.
we'll examine it. In the earlier round, these things should have been
My
taken.
lord, I approached the honorable court with a writ petition. I have annexed the order, my lordship, page 21, my lord. I myself came before the honorable high court. The annexed for page 21, my lordship.
Yes.
When the meeting was called by Anchalik Panchayat, at that time, my lord, the honorable high court on 24/6/2022 passed the order, my lordship. In that order, my lordship,
We'll see if it is done as per 15 or not. We'll see that. We'll examine it. The meeting will not be
only
stalled.
the requisition notice may be seen, my lord. Only the last submission, my lord. Requisition notice, my lordship. My lord, requisition notice, my lord.
Page
Annexure 1, my lordship. Annexure 1, my lordship. There is a
Picture
requisition.
one must be having a page number.
Yes, my lord. Page 16. Page 16, my lord. Yes. This is delivered to the secretary, my lordship. Section 15.2 is very much clear, my lordship. Request
Request
to
Mr. Abdul Askul Ali Council for the petitioner. Agreed by the convention of the special meeting to discuss the no confidence motion proposed by the petitioner on 29/9/2022. The petition has been filed. Internally, we are continuing that. The procedure prescribed under section 15(1) of Assam Panchayat Act 1994 has not been followed in this case. Mr. S. Bhattal, I will study council here on the party also on the other hand submits that the meeting has been convened as per the granted by this court by order dated by 12/9/2022, passed in WPC number 5080 of 2022. Moreover, the provisions of section 15(1) of the Act of 1990 have been complied with in this case. As such, there is no scope for interference in the matter by this court. Taking note of the sufficient I
Yes, please. But the limited player lordship, this petition has submitted a representation lordship. That has not been considered lordship. But the response of four lordship insisting to make the petitioner lordship from the tax land lordship. They are not the power of the people lordship.
Lordship, no notice, no eviction notice has been
Yes.
with the petitioner, Lordship.
Lordship.
Moreover, it's a pass land. The government has land.
That is really applicable. Only the
Then what can be done?
That's only the response number four lordship might be lordship is other motive lordship who is
Mere apprehension.
Yes. So then for the lordship, we have submitted a replacement before a deputy commissioner on the 7th May 2022. So let's make simple lordship definitely consider that replacement may be considered.
What representation?
Yes, sir. The page 4.
Page 37, translated type.
Response number lordship, four lordship trying to evict this petitioner. He is the president of the corporation lordship and he is trying to evict the person and trying to start a lordship.
Why are you saying you will be evicted? Who has said that?
Yes, the response number 4. I have specifically mentioned in the petition also.
Which paragraph?
Yes. Let me come to page 10, paragraph number 7. And paragraph 5 also. I have mentioned.
Page 8, Your Lordship, paragraph 4. We have said
Who is the response number 4?
This is the president of the government, that government. Under which this land belongs. He has no authority, lordship, but still lordship is insisting and triggering. That may come to
Artificial cause of action.
no lordship, may I have specifically mentioned page number 10 lordship, page number 7. That may apprehension or apprehension lordship.
No, you can't just file a case and get a status quo order saying somebody who's totally irrelevant here has.
Lordship, after getting such triggering lordship, we have filed a apprehension lordship. And that is not yet considered. So, lordship,
No, they will not consider. These are not necessary.
no lordship,
Let them obtain instruction after vacation.
still then lordship,
This kind of petitions we can't entertain. These
lordship,
are-
yes, lordship, there is no cause of action, but still that lordship, there is only apprehension lordship. They are lordship landless person lordship, the private person lordship, and they are occupying that person. We have specifically agreed also, they are occupying a government land. Only the person lordship, Arjay Modi, he is trying
They have
to.
obtained instruction on motion, nothing beyond that at the moment, Mr. Kalita.
Lordship,
Not
there is an instruction in the lordship, we may not be evicted.
No, that order cannot be passed like this.
That very fixed.
Huh?
That immediately after that will be.
Yes. But Mr. J. Kalita and the county. The petitioners claim to be landless person in the application of government khas land. Appealing eviction from the land, they have approached this court by filing the instant petition. It appears from the pleadings in the petition that the apprehension is based on a declaration made by respondent number 4, who is the president of some government chapter, that the petitioner might be evicted. It is, besides that, there is nothing to show that there is any more to evict the petitioner.
Yes.
Therefore, it is doubtful as to whether there is any proper cause of action for the petitioners to approach this court at all. Be that as it may, after hearing the oral submission of Mr. Kalita, this court is inclined to grant time to the Government Department Council to obtain instruction responding to the allegation made in the petition. Let this matter be posted for motion immediately after the opening of the petition. Two extra copies will furnish to the court.
Online.
44 may be taken up along with item 32, to connect with the
We have surrendered order passed by the Granite Assam Board of Revenue Lordship, not entertaining the appeal filed by the petitioners on the ground of delay order without entering into the merit of the case. That order is at page 115. But without entering into the merit of the case, lot of things has been described in the order.
Which is the order page number?
Page number 115.
115.
Annex 11.
What was the order date in 19 to
No,
2006?
it is the at the page 68.
What does it say?
It says that the preliminary decree passed by civil court that has been executed by this order, by the settlement officer. That order will have service. The part of the portion of the land we have purchased by registered sale without setting aside the registered sale, the shareholder of the property. They have challenged the mutation orders. That mutation order has been satisfied. By executing the preliminary decree, that which decree has never been executed. Way back in 1999, that
So we issue notice.
lots.
The order date is 10 minutes. Some code of revenue. Notice of motion return of these weeks since we send order damage standing council revenue department of Assam.
Correspondent number 1,
And it's M. Burman
3 to 5.
and Government Education Assam. Further notice of required in the same. So respondents. The name of the respondent party is struck off from the other parties. Necessary endorsement. Petitioner takes steps for service and notice. As such, service of notice and respondent. 1, 2, 4, 5, extra copies of the notice should be furnished. Petitioner takes steps for service and respondent. Registered post to the review.
Permitted dusty also. They are from Guwahati.
Yeah, enough time.
Lots of can it be if we permitted by dusty? Can it be
No,
after
because
after 5
these are
years?
not important urgent matters. Important, but not urgent matters.
Lots of the private restaurant are pressing on the execution of the order.
Cannot be, there are remedies available. You have to understand how the law operates. Because of misunderstanding of law, it doesn't become urgent matter.
And it gets.
That your lordship, lordship kindly go to page number 7, lordship, para 4. The original Khapiyan number 173 was issued in the name of two persons, lordship, Damesh Ali Sheikh and Meher Ali Sheikh. Both are sons of late G.R. Mandal, lordship. Lordship, Damesh Ali Sheikh left behind no heirs, lordship, and Meher Ali Sheikh left behind 4 sons, namely Jalaluddin Sheikh, Naziruddin Sheikh, Asghar Ali Sheikh, and Samadullah Sheikh, lordship.
Why are you appearing in eviction?
Lordship, the Ponson Latmangal and some official persons go to the land and measure the land, lordship, and they verbally inform the petitioners, lordship. But no formal notice has been yet served, lordship.
All right, so we'll close it by providing that if they can produce any document show that they are not encroachers, then they will not be evicted without serving notice.
Later we speak instruction.
Then we'll maintain status quo. What do you want to do?
immediately after future.
Or I've heard Mr. Everett Center and Council for the Petitioner. There is the awareness about the petition. The petitioner is very legal rights of persons who have occupied certain plot of land based on appearance that were issued by the Jamindars, for instance. According to the petitioners, they are possessing the land. They are not encroachers of government land, but are in occupation of the land by paying revenue to the government. However, recently, the response number as such, this lead petition has been filed eviction without following the due process of law. In support of this argument, Mr. Sathya has invited the attention of the documents annexed to the petition to show that the petitioner is not illegal encroachers in respect of the district. This unlawfully standing down the revenue department and Mr. B. David and the government applicant also like received instruction responding to the allegation made in the petition. In view of the above, issue notice of meeting on 9/11/2022. Since Ms. Bordello has appeared in accepted notice on behalf of respondent number 1 and Mr. B. David for respondent numbers 2, 3, and 4. Service of notice is deemed to be complete in this case. Extra copy of the petition be furnished to the learning department of council within a week from today. And how the matter of including having regard to the facts and circumstances, I believe the documents available on record. It is hereby provided that the petitioners shall not be evicted from the land without serving prior notice.
Your Lordship, according to the order dated 14/9/2022, I have find the present petition for impeding the present incumbent as the earlier incumbent has already been transferred.
Present incumbent in the office of Secretary DPC.
The Principal Secretary DPC and the Additional Chief Engineer, Borland Territorial Council, Kokrajhar.
So we'll allow the application.
Lordship, in some other methods are also there. In this case, they have filed an application, but whether the copy was received at the office or not, that is not there. Copy of the order.
Have you demanded compliance of the order from them?
Yes.
Huh?
Yes, my lord, because this is the order of order passed on
Any statement?
on 8/4/2021, order was passed in WPC number 3586 and
No, that's not the question. These persons you want to impede now,
yes,
have you means your client, have they demanded compliance of the court order?
yes, my lord.
When and how?
They are personally they are
You think they must have done it,
yes,
but you are not sure.
Not-
But that the law is that there has to be proof of demand of compliance. Otherwise, they cannot be impeded.
and the lordship, they had personally one mistake is done that the notice was in the hand of my client. The copy served to me. Receipt copy is furnished to me, but the notice which was issued, I had furnished to them, but that was not furnished to me. That is why I could not submit before this court matter. Actually, they have furnished the copy on 21/9/2022, and by mistake they could not furnish me
The
the
copy of the order was furnished on 21/9/2022. Then we cannot entertain this because your application is later than that.
yes, ma'am.
Your application is prior to that.
Yes, ma'am. I have to take step to the present incumbent to furnish the copy, and thereby I will file an affidavit with the matter. That means and another matter was listed today before.
So you want the IA to be pending.
Yes, ma'am.
You want to file additional affidavit.
Additional affidavit with a notice to the that I have taken took the notice to the newly incumbent, and accordingly I have filed an additional affidavit Whether it is clear
So
that
you
they
will
are,
have to not only demand compliance, but give them the time mentioned in the order of the court.
yes.
You can't give it today and say that tomorrow you comply. That's not going to happen.
But earlier, I had contempt filed on March.
You are saying earlier order courts have passed orders.
Yes, my lord.
Tell me which is the correct procedure. I will follow the correct procedure.
No,
Not
my lord, when the contempt case was filed and accordingly notice was issued to the earlier contender, the earlier contender did not comply the order, my lord. And according to the information from my colleague, the principal secretary, earlier principal secretary was transferred 1 or 2 months ago.
that is correct. The earlier contemnants are not let off the hook. They are a part of this procedure.
That will be possible.
But the new persons who come in,
But
give
that-
them the order today and implement them tomorrow. What is the purpose?
Only on 14/9/2022, I came to know that the earlier contender was transferred.
That's not the point.
Yes, my
Point
lord.
is something else.
Yes, my lord.
If the court gives them 4 weeks time to comply with in the original order, here also you have to wait for 4 weeks. They can't comply with the order overnight. In the contempt case, this is the law. If he raises an objection, how the court will brush it aside? He's saying so. So after serving notice, you have to wait for 4 weeks. And then only you have to say that there is a violation of court's order.
Yes.
How can you say that otherwise? So I'm adjourning it so as to enable you to find additional activity. And the request of Ms. This IS stands open as to enable her to find additional activity. In letter, proof of the fact that the petitioner demanded compliance of the court. From the new incumbent in the office of Principal Secretary BBC and Additional Chief of India. So the other respondents are not out of it because they have been transferred.
Lordship, I'm appearing for one, and the person I'm appearing for, Lordship, he was transferred out even.
What did you
before
do before you was transferred?
Lordship, even before the notice was served of contempt. Even before the notice was served of contempt.
Contempt notice?
Yes.
Maybe, but did you complain with the court order?
That instruction I am appearing.
That you have to tell us because it is transferred, that's not a ground. When the court passes an order, it has to be complied with or you have to appeal against that.
In the meantime, Lordship, I'll file an affidavit on behalf of the
Mr. P. Nayak, Nanak Council for number 1 of the I'll affidavit on the request of Nanak Council that this notice is to begin after the vacation. You may find things technical, but at the end of the day, these things cause far more delay than what happens in a proceeding. In a contempt matter, if the court catches hold of the officer, he is entitled to take technical view. Then we'll close it. Please tell them.
Item 32, there is an IA by the DAIL, Lordship may take up the IA first.
IA, my suggestion was subject to what your Lordship says. IA can be taken up at the end because it has to be decided along with the petition. If Lordship so pleases, I'll make the submissions on that. The IA is essentially to withdraw statements that have been made on behalf of respondent number 1 corporation regarding deposit of certain compensation. 16/6/2022 was when the first statement was made. And that was the first time the Lordship was considering the interim relief that is to be granted. So to avoid any interim relief, the statement was made that we are willing to deposit compensation. I must immediately say, my lord, the compensation under section 10 has not been determined yet. So what was offered to be deposited was a kind of an ad hoc compensation subject to
what would be determined by the competent authority in the section 10 to be disbursed at the relevant time. So to show my bona fides and to avoid any interim relief. But the reason why that statement was made must also be said, my lord. We have explained that in our application. This is a project of national importance. This is the Barauni-Guwahati pipeline. About 722 kilometers across 3 states, 245 kilometers to be laid within Assam. We are concerned with a 250 meter stretch. We have said so on affidavit that 240 kilometers out of 245 kilometers have already been laid. Out of 5 kilometers, 4.5 kilometers, 4.75 kilometers lots are to be laid under reverse, and therefore it is taking some time. No dispute. The entire dispute is about 250 meters stretch, which is going to go under the land of the petitioner. Now, if this 250 meters stretch is going to jeopardize my entire 245 kilometer of pipeline laid in Assam, that is going to cause huge, it will not be in public interest. And therefore, we wanted to show our bona fides by offering to deposit compensation, because ultimately the entire thing will boil down to compensation. What the quantum should be, Section 10 proceedings will be initiated to the competent authority. This does not represent a typical case because there have been constructions, whether these are legal, illegal, etc., have to be gone into by the competent authority, and ultimately a call will be taken. And whatever award is passed, subject to a right of appeal before the district judge, knowledge will be paid. There's no difficulty there. But today, there is a stay. There is a protection of possession of the petitioner with respect to his land. And therefore, we are unable to proceed with the 250 meter stretch. Everything is lying in readiness. They have been welded. They would just have to be laid.
Mr.
N.L. Ganapati.
Mr. N.L. Ganapati, you are appearing for the bail.
For bail.
You see, to put the long matter short, there are only 2 aspects which call for court's determination today. The fact that it's a project of national importance, there can't be any doubt about it, and it needs to be expedited, is also very well taken. Correct. When the order of the court was passed, there were considerations such as this is the only dwelling house of the petitioners. So the court was conscious of the fact that pending adjudication of the legal issues, the work cannot be stopped. At the same time, if the land and house is taken away, the petitioners cannot be left high and dry. The determination of compensation may take any number of years. So, since there is no dispute that compensation will have to be paid, the court wanted to work out a middle way to resolve the issue at least temporarily, so they also agreed that we will vacate the land provided you give us some compensation, which will be adjusted with the determination of final compensation. If your argument today is that we will not pay anything till the determination is made, and you want an urgent order, it may be really difficult. We can pass a judgment to say that this offer, the amount needs to be modified, etc. The court is open to hear. But if a person who is living in a house with his family has to vacate it, to ask him to wait till a determination is made and appeal is made before by that time his life will be gone.
Point well taken. Only one submission.
So I am putting you on notice on this. Otherwise, there is not, you need not labor on any other point. The other things which you have submitted, it will not require any convincing act in this case. Only thing is, now you want a final disposal of the matter today itself?
In fact, there is a Supreme Court order whereby a request has been made to this honorable court to decide this matter within 4 weeks. And therefore, when the matter came up on 14, the lot to pitch it.
We can try, but I'm putting it to you that this will be in that case, we'll take it up. Let's finish up.
I only one point that I have to make to respond to what fell from your lordship just now. The petitioner, admittedly, was not residing in this land when the 3-1 notification was issued. He is ordinarily a resident of village Nanara in his ancestral home. This is an admitted position on record. So it is not that he will be on the streets if he has to vacate and surrender the land for the project to be completed. The whole issue is about 3-1 notification came on 16th of October 2018. whether any structures put on that land on 16/10/18 is a core issue. That has been gone into with the competent authority, and he has returned a finding that no such structure existed. And therefore, my lords, the objections filed under section 5(1) have been rejected. It's a finding of fact.
All right, you see, I have seen the order of the Honorable Supreme Court. Make an attempt, but decision of the matter has to follow the legal principles. Therefore,
My
I
respectful
can't guarantee you whether it will be decided before vacation or after vacation.
I mean, I leave it to your
But
lordship.
then
on
the
that.
question is, yes, these are urgent matters. Some cooperation from both sides will be required. Otherwise, we'll hear and see when it can be decided.
Very, very good. Only the other point that I wanted to make out was compensation is really not the subject matter in this.
That's not the subject matter.
Right.
But the court wanted to expedite the cause of the game.
Yeah, balancing the interest of both
That's
parties. Very well taken. Very
But
well.
the Red Court doesn't have the jurisdiction to do that balancing.
Of course, no difficulty at all. But the question really is, what is the basis on which the compensation will be taken? I mean, that's the point. Today, there is no material malus on record based on which a compensation, even an ad hoc or a provisional compensation, can be worked out. Because notice was issued by the competent authority to the petitioner to provide such information, not provided. He does not cooperate, and therefore
I
the delay.
strongly object to such statement.
No, I'm born from the
These are
record.
not the issues to be decided by this honorable court at this moment.
No,
Everything has been decided by earlier rounds of litigation. Number one, your lordship. Number two, your lordship, competent authority passed an
All right,
order.
Mr. Bhatnagar, Mr. Gandhi. Please come back at 2. See if you can assist the court on that.
Very
Otherwise, we'll hear, and again here, and again here. That's not helping anyone.
Very good. Great.
And the honorable apex court order is from about 4 weeks from the date of submission of copy before. this
Those are
order.
fine. These are requests. We'll definitely honor the court's. But
Great.
the judgment of the court will be in accordance with law, not under any directive of any.
Sir,
So if the court is convinced that this is the judgment will pass, in that time we'll have to hear the matter. And the problem is we have the vacations from day after tomorrow. So during vacation, we can't hear this matter.
that's
So if it is not concluded by today, it is definitely going after vacation.
certainly.
And we'll record the reasons.
Certainly.
Under the Supreme Court.
Of course, the endeavor will be made by this court. That's all.
Which will be definitely honored.
Sir.
It has to be.
Of course.
And even the facts of the case justifies that. But then if contentious issues remain unresolved and further hearing is required, then the matter will go after vacation. Nothing can be done. So it is in that context, I am requesting both sides. Use this 1 hour, 15 minutes, best use, and see if we can find a way out.
Well,
So that I can dictate the judgment right here and finish it.
great.
If contentious issues go on, if there is no agreement, then it will take time.
Great.
Deeply observed.
The last petition, your lordship wanted me to give a judgment delivered by your lordship. I find it out.
You are seeking disposal in these matters.
No, the interim order matter was. The matter was heard by your lordship on that day. And when this order, the lordship is on 16/9/22. May lordship make some observations to that effect.
16/9.
2022.
I'm led by Mr. Didas in this case.
The similar care was made in the last petition, sir.
He's out of station today. I'm waiting for it today.
It will be difficult. This has been fixed and you come on Sunday then. Out of station 2 days before vacation, urgent matters, we won't be able to accommodate this. I'm so sorry. You have to make do with whatever you have.
Can it be there?
No matter will be adjourned today, any day, today, this week, tomorrow, day after. Already other cases are there.
My bid was 3 crores 43 lakhs. and their bid was 1 crore 22 lakh.
There are two rate petitions, is it?
He is second bidder. I am first bidder, and he is third bidder.
So what is your rate petition number?
4450 of 2022.
You are the highest bidder.
I am the highest bidder. My bid was 3 crore 43 lakh 43,949.
And settlement has been awarded in favor of
Third bidder 1 lakh 22 crore 50,000.
half. Why is it so?
According to your lordship, becomes page 42. Why my bid was rejected? Page 42, Roman 4, clause Bakita clearance certificate issued from the certificate of defense office SDO. Bilashipa is found to be attached with their tender, where it has been brought to our notice that the certificate was issued on 26/6/2018, but as per the norms, the validity of Bakita certificate remain in force for a period of 3 months from the date of issue. That is one ground. And then you have to come to clause 8. Roman 8. And clause 9. Well, clause 9 is the required PAN card in the name of the society is found not attached with their tender, but the acknowledgement receipt for obtaining PAN card is found attached.
You are reading from page?
Page 42. Clause.
Okay, now this is all fine, but today you are asking for an interim order, saying what?
The stay of this.
Then who will run it?
Government will
That order cannot be passed. We will, the judgment is on the point. You have to set aside the settlement. Today it will not be, or you wait till the other matter is over.
That's 1 year. More than 1 year.
That is correct. We'll pass an order.
All right.
Let other matters be over.
All right.
We'll work till 8 o'clock, no problem.
We have filed in both the cases, my lord, activity in opposition has been filed by the government. My lord, what my submission is, my lord, my lord, entire matter may be heard and definitely disposed of immediately after vacation. That
They are asking to be done
interim
today.
order, my lord, they have.
No interim order will be passed. Final discussion.
My lord, March, my lord, the interim order was, my lord, passed. They have preferred the expedition in June, my lord, last part of
Because of the fact that we did not get the certified copy. The certified copy has to be obtained at his instance by invoking RTI. All these things are happened. So it is better not to open all these things.
Why don't we have it on 31st and finish it off? Dispose it off. Taken up for disposal. See, I'll have it today, but you know ultimately this matter will not be heard today. You will not get a judgment.
Yes,
Let us be
that-
practical. Because there is another matter where there is an order of the Supreme Court to decide the gain matter.
Definitely
That-
that matter is.
That will take the whole time. You want to wait, you wait. But then it's not going to happen.
Let us be practical.
And,
We are
this is a final relief has to be granted. Either set it aside and issue a mandamus to give it. Now he is also claiming, you are also claiming. So
But
between
if
the
I
two,
fail, then he may get.
so everything has to be in one order.
Yeah.
One judgment only.
I leave it to your option, sir, because only 2 days are.
No, tell us because we understand you have urgency, but then what to do?
I leave it together.
When? 1st November or 31st October?
Then we get to the.
It's a hard mistake with us. I'll take it 1/11. No further final disposal at the stage of admission. Parties to come with the recording. Yes.
My lord, I am the my lord, mercy of the my lord, board list and one needs to be expired by 31st of this 30 of this month, therefore tomorrow. My lord, during the COVID and Khan and my lord, I suffered loss. That's why I made an application for extension of the my lord, 2 years. There is a provision of Rule 19 and 18 for extension. I'll also pass an order earlier. my lord. Similar order may be passed.
As per my instruction, all quantity has been expected lottery. On 19/9/2022, all the quantity of sand allotted against the sand hall number 2 for the entire period of second year is almost removed. Expected 198 cubic meter as on sand can be removed within 2-3 days by the Maholder. That means from 19 to 3 days, 21/9/2022, all the amount. Already it
My lord, this is not correct, my lord. Not correct.
as per my instruction.
Let them dispose the representation, my lord.
What is your representation?
My lord, the representation, my lord, page 34, filed on my lord, 5/8/2022, my lord. Annexure 6, page 34. my lord.
Process of return has tender is also almost initiate the process.
Notice been
No, madam. No, madam.
Notice or dispute lawsuit process has been started.
maybe, but you can settle it within 2 days. So consider his representation and allow him till the next settlement order is issued. Next two orders will pass.
My lord, I
Earlier,
just passed, madam.
Raju Muru text. Public
Where is the earlier order?
My lord, take with that record, that this was a matter also, my lord. Publication number 5962.
596220.
So it's
Order to approve, my lord.
this is also Varanasi.
My lord, this is one, this is two, my lord, that one is three, my lord. This one, three, my lord. This was one was three, this two, my lord.
The Mohan was settled for 7 years.
My lord.
Because the hard to stay on something like council of verification. Varanasi Sarwan number 2 was only a settled.
This is two, my lord. This one is two, my lord.
Varanasi Sarwan number 2. 7 years. While operating the COVID-19 pandemic broke out. Apart from the fact there was protesting education due to incidents such as Citizenship Amendment Bill, as well as passing of CAA. The petitioner contended that due to the above he could not operate the San Mohan properly so as to defeat his law. As such, the petitioner had submitted representation dated. What is the representation number?
My lord, 34, my lord. 5/8/2022.
5/8/2022. Addressed to the Divisional Forest Officer, Baksa Forest Division. It's a prayer. Extend the settlement period for a further 2 years. For further 2 years. However, no action has been taken on the said representation. Mr. Saravya submits that this period of settlement, the original period of settlement with the petitioner was come to an end on 30/9/2022. And the respondents have not yet united for fresh settlement of the matter. It is also the submission of mistake. Another petition being WPC number 5960 of 2022, filed by the similarly situated Mohalla of Varanasi San Mohan number 2, with similar grounds. It is passed in order granting relief, granting partial relief to the petitioner therein.
It will be 3, my lord. Born only it will be 3, my lord. 3, my lord.
That will be 3. Varanasi San Mohan number 2. As such, a prayer has been made for issuance of it. Similar order in the present case of it. This foreign SCBDC submit that petitioner has practically removed all the quantities and therefore this representation was not considered. Planet Standing Council has admitted that although the process is on for issuing fresh NIP, same has not been published this today. The application number 5962 of 2022 signed by the settlement holder of Varanasi Sangho number 3. And similar grounds was disposed of by this court with the following observations. Since the petitioner is similarly situated and claims to have suffered losses due to similar reasons, I do not see any justifiable ground to adopt a different approach to the present matter. As such, this liquidation is also disposed of by directing that observations made in the order dated order dated 29/2022, passed in WPC number 5960 of 2022 shall be applicable in the present case as well. Certificate copy of this order before the concerned authorities.
Hello.
May it please your lordship. My lord, this is a content petition lordship. As on today lordship, I have not got the electricity lordship. Order passed the reasonable court of 11/3 lordship. And I have made about a copy. Where is the order? Lordship, page 13 lordship. Page 13 and lordship this delivery cost. We will issue notice. Also already it is issued lordship. Already it is issued lordship and also lordship office note dated 23/8/22, AD card received by one Shankar Burman on 30/5/2022. Lordship, I have made a copy to the container lordship. The container has not installed the electricity lordship and he has received the standing council. Willing to comment to lordship.
What's in the matter maybe pass over for time being? My seniors are left at court number 2 for the division rights.
This is the second round. Your lordship, order your lordship has seen at page 37. This is about the license, liquor license at Anguli. The first case, some people filed a case here that is at page 37. One name, petitioner number 2 is Bilal Kolita, your lordship just make a note. And this is your lordship judgment at page 42. Next, your lordship has discussed the issues with regard to Rule 289(2). And what is finding is that page 44. Because people can object to the in certain areas. So your lordship has quoted the report which was submitted and the distance has been mentioned on that page 44, paragraph 15. The lordship finding is
Who is the senior?
Lots of Mr. BD code. You can take it after some time.
you may come at 2 o'clock, let me complete because we
We'll take it up at 2 and finish it on that.
will.
Of license. Please, Your Lordship. In this case, there was an interim order and that has been complied. So today, they have to appear and file affidavit or whatever they would like to. This is related to the elephant in Chennai, Lordship.
So what has happened there?
The inspection was done. And I am yet to receive the hard copy of that report. Inspection was done and it was found to be healthy, but there were some marks also. And the opinion of the doctor is that the elephant is feeling very lonely because they have to always remain with some groups.
whereas the elephant is staying alone, there is some issues there. But 3 years is over, so legally the Assam government can bring it back. The law is well settled and well, very clear. There is no vagueness, ambiguity in that aspect.
So what is to be done?
Let it be posted after vacation. Because by that time,
Application for intervention, improvement, that may come along with the
Mr. B. Sekhar, learned advocate with an Assam. Anybody else? Appearing for the response number 1. For the remaining respondents, from the office note, it is not clear as to whether service or duty is complete on the other respondent. In view of the above, let this matter be listed again in the second week of November, along with service report. Since Mr. Kiran Chaudhary, that is senior counsel, has appeared and submitted that, and IA being, the number is there, IA number
12187 is the filing number.
This filing number 12187 dated
Yes, it is. Oh, sorry, 28.
9/2022 has been filed to the jurisdiction improvement of the applicant registered to tag the IA along with this petition and this together.
Deep problem.
Item number 70 is what is given a date of 2nd of November. But in fact, on 2nd of November, myself and Sahil will be out of station on the day. Second and third. Either when I have taken a consent from the other side of the government as well as Toronto also. Either 1 minute or 4th or 5th minute, subject to the convenience of this court. Fine. Maximum.
Let someone make a mention. It has already been online. Things move a little fast here. Sorry. So, how much time will you take, Mr. Ganesh?
So, the non-friend has to start. They are the petitioner. I'll take about half an hour is what I anticipate, subject to.
But then we have an orders matter. We'll just take 15-20 minutes.
Very good.
Mr. Pathak, what is the matter? The officer has received notice.
Yes, Lordship, no, I am not holding it for Kalatnama. I just inquired. What has happened is that the petitioner and the respondent number 1 are brothers. We have in fact attempted, we have made 7 attempts to restore the electricity connection. The law and order situation has been created, Your Lordship. In fact, 2 FIRs have already been registered from our part, Your Lordship, regarding this, Your Lordship. And on the last day, even though after the last order was passed, even after that, we made another attempt. On that day also, we were prevented. We have lodged an FIR saying that this is the situation. As soon as we go there, force is employed by the respondent number 1, who is also a party here. Not in the contempt proceedings, in the writ petition. Because of that, we have not been able to use that.
But you received notice, the contempt.
Yes, I have to just told him today sending a Vakalnama, but perhaps I'll file the Vakalnama by tomorrow. This is the situation, what is informed me. More than 2 FIRs have been registered, and 1 FIR after the last order is passed by the court.
So it is not a case of willful violation. Let him appear, but in the meantime, you think what you want to do. Mr. Arshaman, counsel for the petition, also Mr. P. Pathak, and counsel who submit that he has received oral instruction to appear on behalf of the sole respondent, but the Vakalatnama has not yet been sent. As such, Mr. Pathak makes a request to post this matter after the vacation so as to enable him to find the Vakalatnama on behalf of the respondent. There alone, this is the matter of order. But you have to see who is the actual contender. You have to, if your brother is creating trouble, then you have to include him.
Lord, I am extremely sorry. I didn't knew that my senior was appearing on the other side. I was in the midst of a part matter before the division bench where 16 appellants were sent to life imprisonment. My lord, subject to your lordship convenience, my lord, there is no interim order as such operating in this case, but if they are looking for a disposal, my lord, I pray, my lord, that tomorrow your lordship will take up. I'll come prepared with the matter.
Tomorrow is not possible.
But there is no interim order
So we'll
operating.
clarify, there is no interim order.
Yes, yes.
We have to go ahead.
Yes.
Yes,
But there's
no, that your lordship's order itself indicated that your lordship just turn over to the lordship's first order, page 37, page 45. The lordship allowed that to be completed, and that has been completed. That's why we have filed that miscellaneous case.
So what is there in it? What is your?
My lord, today so it will be difficult.
No, Mr.
But your
Paul,
lordship
see,
will take it up.
No matters can be now fixed
My
before.
lord, if I had known my seniors, I would have taken adjournment in that matter. But
That will not be accepted by the.
yes, but
Because on the last date, your.
but on the last day also that same matter is continuing only.
We'll
So
pass an order today itself. You can.
let my learned senior complete his argument. Tomorrow I'll not.
Tomorrow we cannot fix this matter.
My lord, I understand your lordship.
There are other difficulties.
But there is
On
no.
the last date, she was told. that
Yes,
no
yes,
further-
my lord. But today also, my lord, the division bench did not leave me. So, my lord, your lordship can. There is no interim order operating. Your lordship already there's a. If they want further
Mr.
more
Paul,
clarification.
Everything in the court is not about your convenience.
No, no, no.
There is
How can?
something
That's
called
why.
the
That's why.
judge's convenience also.
That's why we always say subject to your lordship's convenience.
Today, this matter will have to be done, or you agree on a date after vacation. It is not convenient for the court to roll over this matter again. And making it very clear. We can't keep rolling over matters.
Your lordship kindly turn to page 45. Of the petition, of the petition itself.
Yes, page 45.
Yes. 17, in view of the above, I dispose of this petition as well as so and so.
But there is some problem with the pagination. Page 45 is something else. Page 45 of the writ petition is representation dated 3/6/2022.
And we have also filed an objection today. It is not probably not in the record.
Now, your lordship's order is at page, it starts at page 37. In the first case, WPC
You are
444,
referring to IA or the writ petition?
writ petition. It starts at 37. I am drawing your lordship's kind attention to 70, page 45, because your lordship earlier has directed that it is devoid of any merit. In view of the above, I dispose of the petition as well as IA by vacating the interim order dated so and so, thereby granting relief to the respondent authority to process the IMF online in accordance with law. The respondent 2 and 3, however, ensure that provisions of Rule 294 of the Assam Board is adhered to later in series. Now, if your lordship kindly have a look at the IA, that your lordship's order is of January 29/1/21, and then DC directed an inquiry to be done pursuant to your lordship's order on 4/2/21, which is at page 48 of this IA. I'm sorry. This is a page.
You can ask your junior to get the
Yes.
conviction.
DC to inspector.
My lord,
You know,
I'll not.
I'm sorry.
Will
Page 49 of the writ. I'm sorry.
can't object to a man of discretion.
No. Page 49 of the writ. I'm sorry. That later
Page 49.
page of the writ petition itself. This is 4/2/21. After your lordship's order, DC Superintendent itself wrote to the Inspector of Excise to pause an inquiry pursuant to your lordship's direction. And that inquiry was done. And next page, the report is given 8/2/21. And thereafter, DC submits a proposal to the state government, which your lordships will find at page 15 of the IRA. Page 15. This is a letter from the government, 15, an HRA from Additional Secretary to the Government of Assam. It is dated 22/21 to the Deputy Commissioner Subsagar. And the subject is mentioned, and then reference is your letter dated 10/2/21. So DC wrote to the state government after the inquiry report came, and the state government now writes back to the additional secretary, writes back to the DC with reference to the above. I am directed to say that the governor of Assam is pleased to accord sanction under Rule 116 of the Excise Rules to grant IMFL online in favor of Santanu Dutta, so and so, Amguri, Ward number 2, at Amguri Town, Ward number 2, covered by that number so and so for a period of 1 year and subject to renewal under Rule 128 of the so and so on year-to-year basis if there is nothing adverse against the licensing. This is on 20th of February. Now, when we, after this below, that is provided under the Rule 294, namely that with the sanction of the government, DC will pass the order of license. And then, below, if your lordships kindly see, we write to the Deputy Commissioner that this is the position the state government has already cleared the thing. Therefore, in terms of 294, you have to give us the license so that we can start. Page 46, last page of the IA. DC writes to us with reference to the subject above. I am directed to inform you that case number WBC 6339 of 2021 in connection with issuance of IMFL license in favor of you, which is sub judice. This is for your information. There is no interim order in the second petition file. Nothing. The Deputy Commissioner's proposal has been accepted after inquiry pursuant to your lordship's order, and the state government has given the sanction, which is contemplated under the rules 284. If your lordships have a look at that.
6339 is filed by your client.
Yes.
To support your
Yes.
petition.
Yes. Page, if you in the book, middle, it is at page 169.
And what is the challenge in 659 petition?
Same challenge with that. And it is by another group of students group. And the affidavit in opposition is filed by the state government, giving the details as to what they did after your lordship's order and the sanction granted. And they have also filed a objection or counter, and your lordships will find in that the complaint annexed is that of Bilal Dutta, who was the petitioner number 2 in that first case where your lordship held that the petition is devoid of right. So the nexus is absolutely clear. And in any case, because under the statutory rules, your lordship have pointed out from the very first report that the distance is also mentioned. It is 75 feet. And that the state government's affidavit also mentions that. Therefore, apart from anything, look, there is no interim order of the Lordship. Court. The Lordship first order itself tells them that you complete the process. They have completed pursuant to a Lordship order. Proposal went to the state government. State government gave the required sanction. And the contempt which was filed, that has also been dismissed because pursuant to a Lordship order, they have already complied with that order. And 295 specifies now, which your Lordship first order to indicate, that the objectors must be within a particular radius, 75 feet, which they are not. Even in the first case, even now, it's a student's body taking up for this, and the idea which petitioner's complaint is again being repeated, and obviously will have been some. Therefore, there is no stay order. Therefore, why should the Deputy Commissioner be waiting after the sanction has come from the state government? 294 contemplates that. That sanction has come. Therefore, your Lordship will make it clear that the Deputy Commissioner can proceed to exercise his power. That's all.
Just discuss with the IAT.
No, my lord, I have a serious objection. It's not that it's as simple as it has been portrayed. Today we have filed an objection to their application for vacation. It is, I'm told, that it is not on the record. Number one. Number two is that what has been portrayed is not factually correct. Well, the report of the excise inspector is based on some, must be based on some contemporaneous record. Otherwise, he simply for the sake of giving a report, if he gives a report, will your Lordship believe it? So my proposal today, my lord, subject to your Lordship's approval, nearby this proposed shop where it is will open, there is a girls' school, there is a higher secondary school where the students are protesting for establishing of this wine shop near the school. So so let there be a inquiry by an independent body. We'll pay for the cost of that inquiry, and if your Lordship finds that we have suppressed or we are misleading this honorable court, then your Lordship will impose exemplary cost. But when these students are saying that this shop is not conducive for the atmosphere of this school, my lord, I do not want that the court should give a picture that just because on the basis of an inquiry report of an inspector, the ground reality has been ignored by this court and clearance has been given for issuance of this license. Because the Deputy Commissioner knows that the students have gone and protested in his office for opening of this shop. The Deputy Commissioner can't cite to the close his eyes to the views of these local students who are there studying, who don't want a wine shop to be or IMFL shop to be established near the school. So let there be a commission by any advocate commission during this vacation. Immediately on the reopening of the opening of the court, this Lordship will take up the matter. And if we have suppressed, my client have suppressed, the consequences will follow. Because this report of the inspector, my lord, he is trying to justify things which is not supported by any contemporaneous record. Simply making a bold statement in his report that it complies with all your Lordship will not ignore the sentiments of these boys and girls who are objecting to this opening of this IMFL shop. So let there be an inquiry where all the concerned person of that nearby that IMFL shop, the students, the higher secondary and all may be heard. That is one of the mandate that if the liquor shops of any description should not be located at sites to which the neighbors object on ground which upon inquiry. This cannot be just so watertight that it will be always 75 meters and all. It will not, the school is just 80 meters, then the district administration will completely ignore the sentiment of the boys and girls who are studying there. This is not the message.
Mr. Kaur, there are two aspects to this. Let me refer to both the aspects one by one. The first aspect is whether IMFL own license should be granted to the petitioner or not. Is not the subject matter of this petition. It's not the subject matter. So that aspect of the matter will not remotely be touched by this court. The governor of Assam has already granted a license to the petitioner, to the applicant here, in the name of the governor of Assam. And there is already an order of this court that the prayer for grant of license should be considered in accordance with the provisions of the rules. If there is violation of the provisions of the rules, that license will not be applicable. If there is no violation, this court is not concerned about any other aspect. Then you have to move the government to change the rules.
No, my lord, the local opinion of the people has to be taken.
Whatever.
Your lordship will look how the inspector has taken the opinion of the local people or the neighborhood.
Please hear out this. Local opinion is relevant, but it is for the district administration to look.
Probably, my lord, that's why they are not happy. That's why they are not.
So in this IA, the other aspect is what the applicant is saying, that due to pendency of this writ petition, they have stalled the process.
No, nobody has said that.
No, that is the order. That is the order.
No, but the excise department has not said that because of the matter is sub judice before this honorable court.
The only question here is there a stay order operating in this case? What this court proposes to do is to clarify that there is no stay order.
Why clarification is necessary? There is no stay order. Or is further order is necessary to clarify that there is no order is necessary in this case.
Let the government do what they want to do. They are not concerned.
Yes, sir. Let them do it in accordance
They will
with law.
clarify today.
That order is already there. That they will do it in
This IA will
accordance.
be closed by observing that there is no.
No, my lord, my lord, in that case, my lord, your lordship will take note of my objection in the IA which I have filed, and that's why today, my lord, I was preoccupied with the matter. I have heard what my seniors have taken.
After we are preoccupied.
So, my lord, then your lordship will take it up after reopening of the vacation immediately.
You agree?
But I can't say to my senior, your lordship.
Then it doesn't help because
I see your lordship's order.
the last two
I
cases,
have not
only on behalf
objected.
of the matter.
I have not.
Otherwise, I don't seek adjournment. Your lordship has seen.
I
I
have
never
not
seek adjournment.
objected when prayer was made on their behalf on 2 occasions.
Well, I didn't know. First time I know that the sir is appearing in this case. Others, there was some miscommunication. Others, why should I? One
Last
day,
order is of your
I may
lordship.
lose a case, my lord. I will not lose the court, my lord. I'll respectfully submit.
But the last order-
I'll not make submission on the date.
Anything else you want to add?
No, my lord. Today I have not even gone to the objection. Has been filed in the morning today. I have just been given a copy in the court itself. I have also my own limitations, my lord.
Verify with your-
IA. Mr. P.K. Goswami.
And your lordship take note of the objections that are the grounds that I have taken in the objection, my lord. Whether your lordship will include it, but I have taken some grounds in the objections, my lord. Probably I may not have communicated to your lordship all the objections.
Pass on a copy if you have. Do you have a copy, Mr. Paul?
My witness, my document is on.
The government has also filed the affidavit.
Paragraph number five, six, my lord, six.
Paragraph number 6.
6, 7. 9.
Little word that would have to be the complete is correct. Page 20. He was the petitioner number 2 in the first.
The petitioner hearing was the petition number 2 in the first petition.
No, the complaint which is now annexed and which is filed today, that is at page 20. 19 and 20. It is by Dulal Doctor, no? Dulal Polita. And he was the petitioner number 2 in the case which has been disposed by your lordship and which your lordship find at page 34.
Mr. B. Devil and a government advocate assembly. Mr. B.D. Cole, very senior counsel, assisted by Miss Joan Poon, has appeared on behalf of the respondent number 6. The respondent number 6 has petitioner. Application number 639 of 2000. Assuming the
My senior sick PN Goswami appeared and that's why no adjournment is. I thought that why PN Goswami, that the additional advocate general will have so much of interest in it. Now only coming to the court where I ask which item is yours, sir, then he said that is.
you have been misled, Mr.
I have to now see the live streaming record, what she was there.
Internally assuming the IMFL on license granted in favor of the respondent was 6 in the writ petition. That is the applicant here on the grounds mentioned there. Why?
The license has not been the same.
What is the prayer?
There is again the same as earlier, that report and.
Internally questioning the license, IMFL on license granted to the respondent number 6. The applicant in the right. On 23/12/2021, this court had passed an order directing the respondents to furnish necessary instruction to the level departmental council. However, no interim order was passed by this court on the prayer of the writ petitioner. It appears that on 20/20/21, the additional secretary to the government of Assam from Excise Department had issued a communication to the Deputy Commissioner subsided Assam. That is the opposite party number 3. Is it opposite party number 3? The opposite party number 3. Conveying the sanction of the governor of Assam recorded under Rule 116 of the Assam Excise Rules of 2016 for grant of IMFL on license and put license in favor of the applicant operating a shop at Amguri shop at Amguri under ward number 10 in the district of Subsagar for a period of 1 year, subject to renewal under Rule 120 of the Assam Excise Rules 2016. Shop has not yet been opened.
No. This is the last stage.
Despite the issuance of the communication dated 20/20/21, the district administration has not permitted the opening of the IMFL on shop. The additional deputy commissioner Utsagat has issued a communication dated 16/6/2022 indicating that due to the pendency of the writ petition in number 639 of 2021 in connection with his IMFL on license, WPC number 633/2021 in connection with its IMFL own on license, which is substitutes. By referring to the communication dated 16/6/2022, Mr. P.K. Goswami, Mohammed, Senior Counsel for the applicant, submit that notwithstanding the license granted in favor of the petitioner by the competent authority, by taking the plea of permanency of the petition before this court, the authorities are refusing to act in the matter, although there is no stay order operating in the petition. It is also the submission of Mr. Goswami that one of the complainants in this case had earlier approached this court by filing WPC number one of the complainant wherein another petitioner had earlier approached this court by filing WPC number 4440 of the 2020, making a similar player where the offensive petition was disposed of by order dated 29/1/2021, rejecting the prayer of the petitioners. The Lanet Civil Judge had issued a direction to the authorities to process the IMFL own license applied by the applicant in accordance with law, after ensuring that provisions of Rule 294 of the Assam Excise Rules from 2016 was adhered to in letter and spirit. Under the circumstances, the senior counsel for the applicant submitted that there is no justifiable ground for the district administration to drag their feet in the matter only due to the tendency of this petition. The prayer made in this IA has been strongly opposed by Mr. Ford by submitting that there is protest among the local public of Amguri town regarding opening of the shop
As well as by the student of Amguri Girls High School and Amguri Boys High School.
the proximity of the food shop near the Girls High School, Amguri Girls High School.
And Amguri Boys High School.
Amguri Girls and Boys both.
Two different schools. Two different
Girls High School. Mr. Ford submits that merely because the excise rules permit issuance of such a license to the applicant, it still cannot be a justifiable ground to the authorities. No, the protest coming from the local residents of
The interest and objection. Interest and objection of the law.
think that as it may, the only question arising in this IA is pertinent to the issue that there is an restraint order operating in this case, preventing the district administration from allowing the applicant to establish the IMFL on shop based on the license issued to them by the applicant. After recognizing the materials available in data, this court to the effect that the answer which is obvious to be in the negative. Since there is no interim order operating in the writ petition, in the connected writ petition, or in this IA, the respondents cannot take the tendency of the writ petition as a ground not to allow the applicant to establish the shop. Insofar as other issues, if any, are concerned, the same is not the subject matter of the writ petition, since the order dated so and so. Order dated 29/1/2021 passed by this court on similar grievance expressed by the petitioners in WPC number 4440 of the 2021 the said order would obviously provide the fee until such time the order is interfered with by following the due process of law. With the above observation, these IAS can dispose.
Only one small thing, no? But this will not preclude the deputy commissioner to look into the objection.
We are not saying anything else.
Because that will then bar from raising the students when they approach the deputy commissioner. The deputy commissioner may say that the High Court has not asked me to look into it.
Mr. Fuad, if you really insist, we'll pass a judgment. Once there is a, then we'll have to issue a direction that within 7 days we allow him to appeal. Because there is a direction of the court.
I've seen.
Then,
I've seen.
then in order to not to prejudice either side's interest, I've been very careful in dictating. Otherwise, one view would be that this is a clear case of issuing amendments. But we don't want to do it. You want time, you argue. But as of now, the additional deputy commissioner is saying because the writ petition is pending, will not. Why
That
put
is
the gun on
not
the
correct.
court?
That is not correct.
So that is all we have clarified, nothing else.
That how, because there is no interim order in this case, how can I say?
That is all has been clarified.
No, I was.
Let me only note that the government has also filed an affidavit in this matter and saying that pursuant to the lordship order, they have already inquired and submitted that proposal to the government. That is an affidavit.
You add one line, the government has filed affidavit in the writ petition or IA?
Writ petition.
The state has also filed affidavit in the writ petition by stating that pursuant to the earlier order dated 29/1/2020 passed by this court, necessary inquiry has been made. Thereafter, proposal for issuance of IMFL on license in favor of the applicant has been processed. That's all. Highest and writ petition of the right, let the writ petition be discussed again after vacation. Last week. So ultimately, matters will have to be heard on merit. And
Matter will have to be heard on merit. Only one submission subject to lordship's pleasure. The competent authority has the power to pass the award. Now, we have said, even in application 277 that we have filed, besides the withdrawal of the statement, we have said, can we direct the competent authority to pass the award in the section 10 expeditiously so that the compensation can be paid. Because we are not in the way of paying compensation. It is about the quantum. We are not competent to determine the quantum. The competent authority alone can do it. And this is a case which will call for some examination of evidence because even the order of 7th of February 22, Lodge has extended equity only up to 1/7/2020. So that's the date when the petitioner himself admits that came to know about the acquisition proceeding. The equity has been extended up to 1/7/20. Therefore, it is for the petitioner to go and represent before the competent authority what exactly stood as on 1/7/2020 for the competent authority to consider. My submission, my lords, let the writ petition be heard, because there has to be some respect to the request that has been made by the Supreme Court in this honorable court. Let the writ petition be decided on its own merits. But in the meantime, without prejudice to the contention with the parties here, let the competent authority pass an award. Let the petitioner be directed to cooperate with the competent authority so that an award can be passed. If, my lord, it so happens that the award is passed before the writ is decided, your lordship can incorporate that in the order itself. There's no difficulty.
No, Mr. Bhattacharya, other things will hear your argument. So there is no difficulty in hearing argument. The only thing is we are just 2 days before a long vacation. So therefore, the court doesn't want to sound technical. But what the idea was that 14, within 4 weeks, the Supreme Court has asked. That 4 weeks will obviously be excluded from the vacation. That is not the issue. Issue is, this is the urgent matter. The urgency is very well appreciated, and to that extent, this court is conscious that the direction or request of the Supreme Court is with a purpose. So that purpose should not be defeated. That is the main point. The point is not about 4 weeks of 4 weeks, 5 days, that's not the issue. Cases cannot be handled in this manner. But yes, the Honorable Supreme Court has pointed out that or taken note of the fact that it's an urgent matter. If we didn't have vacations from day after tomorrow, then maybe an attempt would have been made to finish off the entire matter. But Mr. Gotaku, you have filed some writ petition that has come up for the first time. What is that writ petition about?
This petition is this, that if you also go to the order passed by the Honorable Court.
Please give the gist first.
Yes,
then we'll
that
go.
is what I am saying. By that order, we also directed them to pay compensation. Now they came and say that this is the compensation assessed by the competent authority.
What is the compensation report?
2 crores 90 lakhs, something euros. 2 crores 90 lakhs. 2.93 crores. 2.93 crores. 2.93 lakhs. 93 lakhs. Now we will not say when this was. We have also agreed to that to the extent you are also subject to the provision of the act. Now this is your lordship on the basis of your lordship on the consideration that this is the project of national importance. Now they took time to take approval from the central government. Your lordship. Then your lordship, what they did, your lordship, then they went up to this honorable apex court. Apex court says that we will not interfere. They dismissed it.
So 1 minute. Let us see which order you have challenged. Let's first marshal the facts a little bit.
Yes.
Which is the order which has been challenged? It is in the IA.
It is
in the IA.
in the IA.
So I'll give you a lot of quick overview.
No. Let me submit. Let me submit. My
Very,
case.
very-
Why are you?
Well,
Mr. Ravi, just take your seat. I'll come
very
back. Yes.
lordship.
That is, your lordship will get it in the IA page number 35 and 36. Order dated 25/8/2022.
No, I'm asking which is the order which was challenged in the Supreme Court by the
Lordship.
Yes.
So 3 interim orders, 16/6/2022.
Let us see the information.
Yes, those are there as part of my IA 2777, Annexure B series.
Okay, just a minute.
21 to 28. Page 21.
Page 23, bottom, your lordship gets the increment.
All right. Possession was protected.
That's it. And subsequently, my lord, this order was extended. This was predominantly the order which is challenged, subsequent was extension. The Supreme Court said since it's an interim order, we are not inclined to interfere.
Which is the next interim order first?
It's at page 25, order dated 22/7. Last line was lordship, please, it's been extended.
Okay, so this is the order where it recorded the 80 lakhs.
That is
Then
they
27. 26. 26.
at 27.
All right, yes. And the order passed by the Supreme Court.
That's page 29 and 30.
All right, so 4 weeks within the date of receipt of.
Yeah.
So when was it released before the court? Which date?
So I will even take it as 14th of September when the last order was passed. So it's, the order records that I had brought the order to the attention of the Honorable Court. So we will even treat it as 14th of September, no difficulty there. So 4 weeks will be from 14th of September, excluding the vacation. We can be clear on that. There's no difficulty. The only thing is the context in which the statements regarding deposits were made were all only, my lords, to avoid an interim order so that the project is not affected, or, my lords, for vacating of the order which was passed on 16/6. Since the Supreme Court said we request the High Court to dispose of the main matter, my lords, the focus shifted from the interim arrangement to the final matter. And therefore we say my statements be not taken. I should not be bound by these statements because they were made in a context. Since the context has changed because of the Supreme Court order, I am withdrawing those statements so that they need not be in the mind of the court when the main matter is disposed of. That is the reason. In fact, we also wrote to the competent authority, because the competent authority had made an assessment on 22nd of July, arriving at some 2.93. In fact, my lord, we were not even aware that the order was being passed, because we said that we are willing to make a deposit, and there was there had been no determination of compensation. But some mechanism had to be followed to arrive at what should be the quantum that should be deposited. It is therefore the competent authority, my lords, in the interest of the project to ensure that the order is vacated, arrived at a 2.93 crore amount. Therefore, my lords, once the Supreme Court passed the order, we wrote to the competent authority saying, since the focus is now shifted to the main matter, you please withdraw this, because otherwise this could be misconstrued. This 2.93 determination was to facilitate an interim arrangement so that the interim order is vacated. Now that the matter is shifting, the focus is shifting to the main matter, you please withdraw it. And that by 25/8 order, that's been withdrawn. It's a an order which is self-explanatory. The context in which the order of the assessment had been made has been explained and has been withdrawn. Now he says that he will have to pass an award under Section 10. And there is the cooperation of the petitioner which is required for him to even determine the compensation under Section 10. Because there is a letter which was written on 4th of June 2022, which is on record, where the competent authority has requested the petitioner to give a series of documents or to provide information which will facilitate him to pass an award under Section 10. That has not been given. The 25th August order of the competent authority also records there has been non-cooperation by the landowner. So now, he has to go before the competent authority, cooperate so that a formal determination can be made. And once that determination is made, we will pay. There's no difficulty.
That's his case. Now, your lordship will kindly note one thing. Can an authority like competent authority corporation like CEO can make such a submission, your lordship, that your lordship to get the interim order vacated, they have somehow, your lordship, passed an order saying that this is the amount of compensation to be paid. Is it not amount to paying fraud on the honorable court, your lordship? Can that be done, your lordship? It cannot be a joke, your lordship, that they come and just because to get an order from this honorable court, they are saying that this is the compensation we are going to pay, and subsequently they will withdraw their statement. That is one point, your lordship. Secondly, your lordship, is there any power on the competent authority to pass an interim award, your lordship, or interim compensation under the act, your lordship? It is not there, your lordship. There is no power under for the competent authority to pass any such interim compensation, your lordship. The compensation, whatever manner he has passed, your lordship, this will be the final compensation under section, deemed to be final compensation under Section 10(1), and only option available to any of the aggrieved parties, be it me or the Gale is to go before the learned district judge as per section 10(2). These arguments he's advancing here, it should be in the
Alright,
before the
all right, what we'll do now is, Mr. Ganesh, we will, and Mr. Bhotagar will obviously respect the order of the Supreme Court. We will hear and decide the main matter within 4 weeks, excluding the vacation time. So that means these matters are going to be fixed for final hearing immediately on reopening. But it can't be before 31st October. Because this bench and there are some other issues will not be available. So on 1st of November, if all of you agree, we can fix it for final hearing. Complete all pleadings before that. No adjournment on that day. We'll hear the main matter and pass judgment on merit. As simple as that.
I am agreeable.
Not going into other aspects. Whatever happens on that day happens.
Great. First November suits me. Only request is, in the meantime, can the competent authority be directed to consider?
No, if it was a mutually agreeable order, there was no difficulty. But he is opposing it. So that would also require a lot of hearing.
Very well.
So therefore, we'll hear the matter once and finish it off.
Very well.
And these aspects will be gone into. If you hear the matters, we'll hear it. And there is a new writ petition which has come today. There also notice has to be issued. And
well, my respective submission will be, the writ petition is essentially the reply to my application.
No, I have put to challenge your particular order of the competent
in my application, I have relied on this order of the competent authority. The reply they have taken that this is not to be done. Your Lordship can take a call because this IA, my IA has to be decided along with the writ petition.
everything will decide together. Today a new writ petition has come, so whether it is maintainable, not maintainable, you put your stand on record. We'll answer it accordingly.
Very.
And then we'll finish it on 1st November, no adjournment. Both sides.
Your Lordship may record that in the order so that we are aware.
Yes, absolutely.
Your Lordship, looking into the importance of the case, Your Lordship, 79 paragraph affidavit in opposition to prepare it immediately so that no delay is caused due to us, Your Lordship. We have done that, Your Lordship.
That is true, but Mr. Bhotakur, the problem is gas pipeline work must
No,
be.
Your Lordship, that is why only very first day when this has fallen from Your
Why
Lordship.
don't you cooperate with the competent authority?
No, Your Lordship, I am cooperating. Now, Your Lordship, once a competent authority passes an order saying that 2 crore 19 lakhs is the compensation we are paying, now can that be withdrawn? That is my case in the second writ
This
petition.
2 crore 93 lakhs is a figure projected on what basis?
They have, Your Lordship, taken assessment from the PWD department as well as the other department, and we passed an order. That is their
Who passed it on?
competent authority, Your Lordship. He is required to pass this order, Your Lordship, compensation.
This is not really an award. As I mentioned, that because Gale had made a statement that they will deposit some amount. That what should be that amount was a question. Therefore, the maximum possible compensation that could be paid under Section 10 was quantified by the competent authority as 2.93. This is the maximum permissible compensation without looking into any evidence.
So, according to you, what is the compensation fee?
Well, it could be much lesser depending on what the petitioner will submit before the competent authority.
So, will you be open to an order that you deposit 50% of the amount and rest it will be subject to adjustment against whatever order competent authority passes?
No, my lord, I have some difficulty because that 2.93 crore order of the assessment of the competent authority itself is not in consonance with this Honorable Court's order of 7th of February 22. Because 7th February 22 order says equity shall be extended only up to 1,720.
Lordship, all these matter will have to be pleaded before the district judge.
Therefore, my difficulty in
Only
accepting
Your
that
Lordship,
assessment.
district judge. No one else
Therefore,
can take it, Your Lordship.
Therefore, my difficulty in accepting 1,720 is the best that they can get. And what the PWD has assessed is 8th of June 22, by which time so much has been constructed. And I must also tell you, Lordship, we have taken certain very strong objections regarding the conduct of the petitioner. The entire earlier writ petition of 2020, when the 7/22 order came to be passed, was on the premise that I never knew anything about the GAIL pipeline project till 1720. 2620 GAIL.
No, no, Your Lordship, I will object
Please
because
don't.
I will object because Your Lordship, this is not our case.
No, it's
Our
good.
case specific. Section 3.1 notice has not been served on us. Section 5.1 notice has not been served on us. And on that basis, an adjudication has already been done by the Honorable Single Judge of
No, I
this
have no
this
difficulty,
court,
Your
Your
Lordship.
Lordship. And if they are aggrieved, they should either file review or go to for appeal. Your Lordship. Now they cannot bring back those issues.
I don't
Your
have to, restate the proposition with broad issues also.
No, no, Your Lordship, there is no
This is
question
very
of law. They
important.
have not
A
brought
very
anything.
serious suppression has taken place. This honorable court have, the writ court had taken whatever the petitioner had stated, the face value and passed them out.
No,
Even
Your
certain
Lordship,
benefits.
they have filed affidavit. They
Even
have
certain
filed
benefits.
interlocutory application for stay vacating. Everything has been dismissed. Your Lordship may take it up on 1st of November. Your Lordship may decide either way.
I am only saying.
This is my humble.
I am only saying that my predicament in not conceding to a 50% deposit, etc., is because of certain circumstances.
We appreciate.
Great.
First, give me the 44, item 44. What is the rich petition?
Probably this is 6/31 of 2000.
My respective submission to Lordship consideration is doing it petition. Your Lordship may issue notice, I'll accept notice, we'll complete feelings, whatever. But if for any reason, this cannot be taken up along with the present writ petition of 32, this may be kept aside because anything can be done subject to outcome of this writ petition. Because the only point that has been raised in the new writ petition is the competent authority could not have withdrawn the 25th of the earlier assessment. That assessment is being put on a higher pedestal as an award. And they say that no, he can't withdraw it. That's the matter for argument. That's really on the issue of compensation. The present writ petition, my lords, is on the correctness or the legality of an order passed by the competent authority under section 5(2), which has nothing to do with compensation. Therefore, my lords, in my respective submission, I have no difficulties if it is clubbed, taken up together, but if for any reason the new writ petition can't be taken up for final hearing, etc., it can be kept aside because that any my lords, it's a common order that lordships keep passing. Anything done is subject to the outcome of the writ petition can always be passed. That is because only that relates to compensation.
So now we'll issue notice and fix it on the same day.
Very well.
On that day. Pleadings and then we'll see what happens.
I will accept notice only on behalf of respondent 1 and 2. So 3 and 4 really are the competent authority and the deputy commissioner. The deputy commissioner is not really a necessary party because it's an order passed by the.
So in this, you are challenging the order in 25 days. Present petition has been filed, assuming the order dated 25 not that the company Assam. Trying the idea of assessment with regard to the land of the petition. According to Mr. Bhattakur, the order in the facts of the case not to have been issued by the without obtaining Mr.
NL Ganapati.
NL Ganapati, council, appearing on that to response number 3.
1 and 2.
Number 1, where made in the petition sometime in instruction. Some motion returnable on 1, 2022, Since Mr. Ganapathy has appeared and accepted notice to Wadipur and Mr. B. Devi, valid government advocate Assam and appeared for response numbers. No formal notice is required to be sent in the court. Extra copies of the disposition. This case is on 1/11/2022. When we come to case against him. 30. That's 14/9/2022. Mr. Ganapathy had appeared and produced a copy of the order 18/8/20. 18/8/20. Page 29. SLP, FFC, SLP preferred by the response number 1. Dismissed. Public interest involved in the request was made to this court. Finally, clear and dispose of the main within 4 weeks of the production of a copy of the although certain issues arising in the matter were dealt with by the interlocutory orders passed on 3 successful on 3 different occasions. Interlocutory orders passed by this court on 16/6/2022 32/7/2020. What have you written? Dealt with by this court by interlocutory orders with the terms which will be subjected to the SLP's preferred by the but in view of the order dated 18 these issues are no longer relevant. The order in the request made by the Supreme Court is the petition will have to be heard in this court of time time frame indicated in the order. However, the petitioner hearing has held another petition hearing number 739/2022 which came up for not 343, 6 which came up for the first time before this court today, when notice has been issued. The issue raised in the affected petition are connected with the controversy involved in the petition. Therefore, some time would have to be given to the respondents to file a petition. Moreover, this court will be on Puja holidays during the period from 1st of October 2022 to 18th of October 2022. Therefore, hearing of the matter as such, although this court is conscious of the fact that public interest involved in disposal of the petition, final hearing of this one 11 as such as the parties. This petition is directed to 6:30 and in view of the request made by the Honorable Supreme Court order dated 18 it is made clear that no request for adjournment will be entertained in the next 8 weeks. The writ petition will be taken up for final hearing and disposal in the next 4 weeks. Parties to participate.
Great. In the meantime, interim order till next step.
Whatever is there is there. What is the
Interim order in the previous protected the
interim order is still today?
Lots. Is it? I think it has been extended from time to time.
That is what you were.
No, even if it is not.
No, it's order to continue.
Obliged.
It is already an order to continue.
Obliged. Keep
So,
your.
if you could just give a gist of the legal provisions in the point both of us, it will help us expedite.
Certainly.
preparing a judgment. And if possible, you can even circulate. You can circulate it.
We will do that.
In advance, so that we can save some.
আইছে না আইছে না the Guwahati High Court, the High Court of Assam, Nagaland, Mizoram, and Arunachal Pradesh. ঠিক আছে না ক্লিয়ার আছে Free access to the licensed premise shall be given at all reasonable times to any inspector of sampling officer, and every facility shall be afforded to such officer for that rules and the conditions of this license are duly observed.
Hello, the Guwahati High Court, the High Court of Assam, Nagaland, Mizoram, and Arunachal Pradesh.